how the property was devolved, who is the original owner, who is the transfer the property, in which favor, whether deed is valid or not. To that extent, amendment was done, not to change the nature and character of the suit. And question of withdrawal of admission does not arise. If the admission, they can admit it by written statement, but the written statement specifically denied by paragraph number 8. Yes. And also in the pageant input order, they are not challenging my amendment. My amendment not challenging by filing the written objection.
Even if they do not file a written objection, you have to prove your case of amendment.
Yes, Lordship.
Merely because the written objection has not been filed, that does not mean that an application has to be allowed.
But they are, but they in the code below, they are not stated anything, Lordship.
Show me the reasons for allowing the amendment.
Paragraph 2 of the impugned order, I filed written objection. I have not annexed it.
Oh, yes, written objection has been filed.
In the input order, Lordship, it was stated written objection, but as per my knowledge, though no written objection was filed.
Anything more?
That was my submission, that the admission does not arise. Withdrawal, question of withdrawal of the admission does not arise because of the paragraph 8, what specifically denied by the defendant by filing written statement with counterclaim, only explaining the fact.
Apart from Modi, তোমার পেজ নাম্বারটা বলে দাও দাদা। এইটা 10-এর 4টা 252 দাদা।
Yes. Any other decision
Yes,
you want to
Milord.
cite? Mr. Mukherjee, show me that deletion part.
Yes, Milord. Deletion part, that's why Milord.
In the application for amendment.
Yes. Application for amendment, Milord, new amendment, page 50,
Yes.
my Lord kindly takes up.
Yes.
This is, Milord, the schedule starts. Kindly turns over the page to page 51.
Yes.
My Lord would get, Milord, from the second paragraph of the proposed amendment. Initial
First paragraph, there is no deletion.
No, first paragraph, there is no deletion.
Only addition.
Yes, only addition.
Second paragraph.
Second paragraph, Milord, the first, Milord, 6 line from the top, Milord, your Lordship.
So in the 8th paragraph,
Yes,
paragraph, some portions have to be deleted.
Again, Milord, this is the first deletion. Again, your Lordship takes up the 5 paragraph from the bottom.
Stamper কথাগুলি লিখিত হইবে. No, this is
Milord, থাকাকালে তাহার অংশ সম্পত্তি কথাগুলি সাফ কলমে কাটিয়া পদস্থলে অর্জুন দলাই. So Kiran Bala, instead of Kiran Bala, he is replacing Arjun in place of Kiran Bala.
Which portion?
Milord, kindly may I read, Milord? 115th অংশ প্রাপ্ত হইয়া ভোগ দখল থাকাকালে তাহার অংশ সম্পত্তি কথাগুলি সাফ কলমে কাটিয়া তদস্থলে উক্ত অর্জুন দলায়ের ত্যক্ত সম্পত্তি কথাগুলি লিখিত হইবে. So instead of Kiran Bala, now Arjun is being replaced. This is the first deletion. Now, Milord, kindly comes to 5 line from the bottom of that page itself. or rather মিলট 6 to 7 লাইন ফ্রম দি বটম, দলিল মূলে কথাগুলি লিখিত হইবে এবং তৎপরে উক্ত দফার পঞ্চম লাইনে কিরণবালা দলাই কথাগুলির পর তাহার অংশ অপেক্ষা অধিক কথাগুলি সাফ কলমে কাটিয়া, গট ইট মিলট,
Yes, yes.
কথাগুলি কাটিয়া উক্ত স্থলে অর্জুন দলায়ের ত্যক্ত সম্পত্তি লিখিত হইবে এবং তৎপরে
So in paragraph 8, some portions are to be deleted.
again মিলট at the last line of the paragraph 51 will your lordship will get মিলট
Yes,
deletion.
yes.
Milord, in the earlier round, they wants to delete Milord as a whole. Now, in a part manner, but the remaining the same thing.
Yes.
Another Milord 2007 volume 5 Supreme Court cases.
Yes.
Milord, page 602, para
Para
19 and 20.
for what proposition?
Milord, this is Milord Milord, what is the difference between the amendment of written statement and plain? Milord, your lordship knows, Milord, in a written statement, even contradictory, self-mutual destructive pleas can be, Milord, brought into record. What the learned judge is saying, but in case of a plaint, Milord, this has been deprecated, Milord, at paragraph 19 and 20 of the judgment. Here, Milord, Modi's ping has been relied. That's what Milord, I'm carrying, but I'm not. হ্যাঁ, ওটা একদম
Yes, anything,
no, Milord, Modi's ping has been relied over there.
this application under Article 227 of the Constitution of India.
Meant with counterclaim specifically denied the paragraph number 8.
So what is your submission on that?
So the question of admission does not arise.
যেখানে opposite party submissionটা রেকর্ড করেছে না ওখানে বলে দিন he further submits that in view of the statements made in paragraph 8 of the written statement
20 paragraph
in view of this
paragraph 27
in view of the statements made in paragraph
14
paragraph 27 of the written statement
14 Lordship.
it what
Book,
yes,
may I
allowed
check, sir?
allowed stands allowed. Please keep it on until it is transcribed. Yes.
Number 7.
Seven, Lord, I am for the petitioner.
Yes.
Not extension of interim order, not. This is my affidavit of service, Lord.
Yes. Interim order was still
Till my 30th June 2025, Lord.
you have served.
Served, Lord.
Why did you not mention earlier?
Lord, I beg to apologize, Lord. I mentioned that on 1st of July, Lord.
Why?
One day
Then it has expired.
later, Lord. That's
Why did you not mention earlier?
I beg to unconditional apology, Lord.
Evidence service filed in court today. Yes.
I am for the petitioner, my lord.
Yes. This is for Baripur court. Do you have any objection to take up? Have you ascertained? Please ascertain.
Oh my God.
Not today. Yes, next.
Order number 9.
They have to promote.
Who is your counterpart in the Baripur court? Who is the learned advocate who is representing your client and the opposite party in Baripur court?
Don't know, your
I
lordship.
don't know. I don't know.
Please ascertain, then come tomorrow. Yes,
Day after tomorrow. Day after tomorrow.
yes,
It's ascertain mode.
yes,
Form করে আসবো।
yes. Next matter.
Can be always.
Number 10.
Petitioner plaintiff is before your lordship, my lord. I'm
Yes.
challenging an order, my lord, wherein the Huh? No, 10, 9, 9. 9, I think 9.
9.
My lord.
Order number 9.
Yes.
My lord, the plaintiff petitioner, my lord, filed a suit for permanent injunction against the defendant, my lord, from carrying out illegal construction, my lord. And also, my lord, from creating any third party right. Ad interim order was granted in my favor. Suddenly, my lord, a third party comes in, files an application to be added as a party therein, saying that he is also the owner of the property. My lord, I am in settled possession of the property since the last 37 years. My deed of conveyance is there. And the tenant has been paying rent to me since the last 35 years, my lord.
Where is your plaint?
My lord, the plaint starts at page 16, my lord. Paragraph 3 at
Who is
page
your
7.
tenant?
My tenant is the father of the present opposite party number 2, my lord. He died in the year 2019. His son is continuing, my lord.
Yes.
He's been paying me rent, my lord, since the time of induction. Now, a third party makes an application saying he is one of the co-owners because of the dark number, my lord. He says,
No,
my
no,
dark
no.
number
Let
is
us keep
Yes.
aside that fact for the
Very
time being.
well.
So, what is the cause of action for filing your suit?
My lord, my suit is he was making illegal construction.
Who was making illegal
My lord,
construction?
the present
The
occupant,
tenant.
the tenant. I filed an application. Lordship, can you see the press?
But you do not want eviction.
My lord,
You want recovery of
I will
possession.
take steps, my lord. I will take steps. In the
When?
My lord, the original tenant died, my lord. I had left it for 5 years, my lord, to keep away the unwanted controversy, my lord, to have a clear-cut case, my lord. Now, if your lordship kindly sees, my lord, my prayers at page 21. I will
Who
also,
is the real person against whom you want injunction, sir?
my lord, it is that very person.
Cannot be this person.
My lord, it is, these are my instructions, my lord. He is running a,
Instructions will not help. Plaint says otherwise. Plaint says otherwise.
he is the person, he is doing it, my lord. He is trying to create third-party rights, my lord, in the property.
Sir, how can the tenant create third-party
My
rights?
lord, that is,
And you are constructing, if he is in possession,
My lord.
in respect of a tea stall, how can you construct, sir?
my lord, because
Without evicting? Without evicting,
Yes.
how can you construct?
there is
There
an
is
underlying
something
dealing.
behind
Yes,
this.
my lord, there is, my lord, but I don't have evidence for that. That is the difficulty, my lord. So I cannot come up with a lordship, my lord. Because I don't have direct evidence, my lord. Now,
Have you obtained an order of injunction?
yes, my lord. That order was passed in my favor, my lord. An ad interim order was passed, my lord. Summons received by the opposite party number 1. Till date, he has not entered appearance in the matter, my lord. If your lordship will kindly see,
It seems that the opposite party number 1, the collusive suit between you and the
No,
opposite
no,
party.
no, no, my lord. Not at all.
That is
not
why
at all.
the opposite party number 1 is not
Your
appearing.
lordship will kindly see the impugned order once, my lord. My lord. It is. I'm being led by Mr. Datto, my lord.
Yes, Mr. Datta.
Not a, my lord, I heard your lordship. Not a question of, my lord, collusion here. My lord, plain schedule is 9584. Application proceeds on the basis
What is the measurement of that plain schedule property?
20 by 11, lordship kindly sees.
20 by 11 square feet.
Yes.
And what is the extent of construction which you are contemplating to make on that property?
My lord, it's he who was making it. I have sought for injunction.
Yes.
The defendant, he was, my lord, the threat was, he was, my lord, trying to make that.
Yes.
My lord, the application kindly sees the order 1 rule 10 application once.
Yes.
First of all, it's a landlord-tenant dispute. Whatever is the relief claimed, my lord, what right does the applicant has in this proceeding? Or what interest can he have?
Show me that it's a landlord-tenant dispute.
My lord, kindly comes to the
You
page.
have recognized him as a tenant. Show me that.
My lord, I'll show. Kindly comes to my
Where
lord.
have you said that he is a tenant?
My lord, page 16 is the plaint.
Yes. Show
But
me
I-
that portion.
Para 3, page 17, and the rent receipt I'll show.
Para 3.
Rent receipt. And read with, my lord, page 24. The rent receipts. And his application proceeds on the premise that it is 9589. But his application, para 5 and 6 says as if that dark number has vanished. That is his averment in the application.
Where is his application?
My lord, kindly takes the application. 57 it starts. And please come to, my lord, paragraphs 3, 4 and 5. And this person, defendant, was there since last 40 years. My lord, if, my lord, the applicant had any sort of grievance, the applicant would have taken steps, my lord, independently. Why in my suit, my lord, and the learned judge does not record any reason why he is allowing the application. And my relief in the suit is not, my lord, relating to ownership at all.
The issue that arises for consideration
because we have taken time.
What
I-
not be affected?
my lord,
Addition.
learned judge has recorded that
Okay, addition not be affected. What is the meaning of that?
my lord,
Then I am setting aside that order without giving them a hearing.
No,
Can it be
I
done?
was, my lord, let me just complete, my lord. Instead of November, I was praying, my lord. It's a short application. It won't take lordship
So
more than 10
all
minutes.
matters according to you are short.
No, not according to me, my lord, but this is, my lord, this
No,
issue is very, my lord.
All issues are short issues. Yes, call the next.
My lord, otherwise I have to amend, I have to implead and then proceed as if, my lord,
Implement has been done, Mr. Dutt.
has been directed to be done. If I carry out this order today, I took time on the last day.
That is why I have admitted your civil revision application.
My lord, then at
But
least record that, my lord, kindly record.
Then I have to stay your
No,
suit.
understand why your lordship is not giving stay of the operation, but my lord,
The
kindly
operation also cannot be,
no, it's allowing the revision application.
and if you want, I can stay your suit.
No, 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 no. My lord, in effect, I have
That
to
is why I have not passed.
in effect, I have to pray for adjournment because I don't want to proceed with OP2 as a defendant.
That is why I have also not passed an order of stay.
Very well. Go ahead, sir.
Yes. Yes,
My lord, I am for the petitioner.
But I'm for the caveat.
yes,
Decree holder caveat.
yes.
The impugned order has rejected my application for ad interim stay of execution. But I am in settled possession of the premises since 2003. I am running a restaurant called Shere Punjab in Theatre Road, my lord. In these premises, my lord, from 2003 I have annexed all the documents, fire license, my lord, FSSAI license, everything. But I have annexed their affidavit filed.
Execution is for execution of what decree?
My lord, decree for my lord eviction of a trespasser.
Who is the judgment debtor?
My lord, judgment debtor is a person,
No, where he
Anjana Talwar, that is the name of the judgment debtor. My lord,
judgment debtor is opposite party number 4.
yes, my lord, opposite
And
party number.
you are opposite party numbers 1, 2, and 3.
I am, my lord, I am not a party in the suit.
Oh,
I have
you are the
filed an
petitioner.
application under order 21 rule
Decree
9.
holder is the opposite party numbers 1, 2, and 3.
Yes, my lord.
So 1, 2, and 3 obtained a decree against 4
4.
for eviction.
Eviction. In
Yes.
2004, they have filed an affidavit before this honorable court saying that opposite number 4 had left the premises and I am in possession running Shere Punjab. In 2011, they filed a caveat.
So what is
against
the,
me.
have you filed any miscellaneous case?
Yes, my lord.
Where is that?
My lord, the miss case is annexed at page number. Page kothay? The my lord, page 40 of the petition.
40.
Yes, ma'am. আরে মিস কেসটা কোথায়? এটা তো সেকশন 151.
No, this is the title execution case.
But in the title
You have filed the
execution, the
application under order 21
ma'am.
rule under 1. Where is that?
My the application just above it is my main application.
So which page?
Page. Yes. My lord,
Yes, yes, I've got
Huh.
that. Page
Page
28.
27.
Page 28,
28.
27.
28.
From 27.
But I pleaded all these facts. They knew it. In 2011, they knew I am in possession of the premises. Their claim is I am a trespasser. 2017, they filed this suit only against Ranjana Tarwal without making me a party and obtained the decree. And but may I just place their affidavit filed before this honorable court? But that is at page 176 in a contempt proceeding, paragraph 7. This is in 2004 they have filed this.
Yes.
Said Aurora has been illegally running an page. My lord, page 182. Their affidavit starts at page 176.
182,
Page
yes.
182 is para 7, my lord. The said Aurora has been illegally running an eatery by the name
You are Aurora.
No, my lord. Aurora is my employee.
Somebody else.
Aurora is my employee.
I will come back.
I am the proprietor. I have annexed all the documents of this Shere Punjab. Their admission is Ranjana Talwar has left. The eatery by the name of Shere Punjab in flagrant violation of corporation rules. They know from corporation I have obtained all the licenses. The applicant trust reasonably believes that upon obtaining undisclosed sums from the said Aurora.
What are the documents to show that you are in possession?
One more thing I am just showing before that, my lord, page 209. They have filed a caveat. In 2011, we have filed caveat against them. They have received the notice. 2009. 209, my lord.
Yes,
Caveat I have filed against them, my lord.
yes.
In 2000, they know I am in possession. My documents, my
No,
lord.
no, show me that
Ah.
you are in possession.
Yes, my lord.
What are the
Kindly comes-
documents in support of
Yes,
your
my lord.
case?
Kindly comes to page 172 onwards. This is my lord, license for running a restaurant issued in 2002, 2003. 172, my lord, 173. These are my
So
licenses.
what is the premises number?
My lord, 7/1A, AJC Bose Road.
My lord, shop room number is important. Let my learned friend, my lord, show what shop room they are intending to.
My lord, Ranjana Talwar premises they are doing, they know, my lord, someone else is in possession. But then fire license, my lord, page 115. This is issued in 2009-10.
Page,
My lord.
page.
My lord, page 154. My lord, 115 fire license. From my lord, 1st March 2009 to 2010, my lord, this. Then my lord, I've been paying VAT, my lord. My VAT return, my lord, will be finding at page 122. Issued on 31st March 2012.
Yes.
Then my lord, FSAI license, my lord, on the Food Safety Act. But that is at page 106.
Where is the suit, where is the decree?
But the decree is at page 18, my lord. Decree starts at 18, ordering portion is at page 24, my lord. Decree ex parte against the defendant. And my lord will find the case against Ranjana Talwar is, she is a ranked trespasser. Not a case of subletting, my lord. 3 minutes. Also have annexed my lord, other documents, trade license, etc. my lord. Electricity bill, drainage license. My lord, my drainage license is from 2002. They are using this decree to evict me, my. Ranjana Talwar is nowhere in possession of any part of the premises.
Where is the decree?
My decree starts at page 18, my lord.
No, no, that is the judgment.
Judgment.
Decree.
My lord, I don't have a copy. I'm
Where
not
is the
a-
decree?
I don't have, my lord.
Do you have the copy of your plaint? Where is your execution application?
I can bring it on record, my lord. I can bring it on record. But my lord, my lord, lordship, kindly come to my lord, the order impugned.
Yes,
Kindly come to the order impugned. Why, my lord, this application was rejected?
yes. Yes. Show me the reasoning.
No, my lord, there is a discussion, my lord, last paragraph.
Yes.
May place, my lord. Peruse the documents submitted by the intervener petitioners applicants. It appears to me the documents so submitted with the application for stay of the execution proceeding being title execution case number such and such are not convincing to establish their prima facie case in respect of the present execution proceeding.
What are the documents?
The document that has been annexed now, my lord.
Yes. So why it does not
Yes.
prima facie prove?
So kindly come to page 4
Page 4
of the application.
of what application? Civil revision application.
Yes. That is the specific pleading. The petitioners, page 4.
Page 4, yes.
The petitioners herein have been holding a distinct, substantive and independent title over shop room number 18 and 19 on the ground floor of the premises number 7/1 Acharya Jagati Chandra Bose Road, PS 6 Sarani, Kolkata 17, since 2001. The document that have been placed before your lordship as well as before the court, my
Show
lord.
me the decree. Please show me the decree. And the execution application, tabular chart.
Tabular chart, my lord, I can place, my lord. Next, tabular chart. Tabular chart.
এটা এটাতে প্রেমিস শপ নাম্বার কোথাও লেখা নেই।
So according to you, they are not in possession of shop room numbers 18 and 19.
No, they are in possession.
I will record your submission.
No.
That you will not disturb their possession in respect of 18 and 19.
Lordship, kindly see. Now, my lord, what are the documents that has been shown?
So there are two things. One is, you know the law very well, that once a third party claims right title, independent right title and interest in respect of a decretal property during the pendency of an execution case, separate suit is barred. All that he has to do, he has to apply under the provisions of Order 21, Rule 97 to 100. That is exactly what has been done. So now, without adjudicating, if the stay is not granted and you execute that, what remains to be decided is I can expedite the miscellaneous case.
That is
Or,
my face, I know.
so if you say no, they are not in possession of 18 and 19, I will record your submission and I will say if they are found to be in possession in 18 and 19, you cannot touch them.
Yes. Now, my lord,
Or I can expedite this miscellaneous case. I can direct this miscellaneous case to be disposed of.
I kindly do that, my lord. But before that, my lord, a minimum document, the documents that have been placed before the trial court, before your lordship, my lord, none of the documents,
All right, I accept I will permit you to execute, but I will not allow them to touch if they are found in 18 and 19.
none of the documents show that these documents, these certificates
Who are in possession in 18 and 19? Who are in possession according to
Ranjana Talwar was in possession.
Now who is
Appeared in the shoot. She appeared in the shoot.
Now I am asking you, now who is in possession?
But they are in forcible and illegal possession. That is not my case. What I am on, my lord. Why, my lord? Trial court.
What is the stage of the miscellaneous case? I am expediting the suit. I am directing this to be disposed of. What is the stage of the miscellaneous case?
Interim was refused. We were directed to serve. That is the stage.
The enter appearance. I will direct this miscellaneous case.
No, that was contested. I think. No, that was not. Yes, let me enter my appearance there.
Yes, what is the next date fixed for entering
25th
appearance?
July, my lord.
25th of July.
Yes.
You enter appearance. I am directing the miscellaneous case.
To be limited, my lord.
Till that time, the execution shall remain state.
And one more thing, my lord. I should kindly execute one thing. My lord, they have filed this 151 petition for stay in connection with my execution, not in connection with Order 21 Rule 97. Whether, my lord, a person who is not in a party.
Take that technical objection. I will say that they will file in that application.
Stay application.
No.
That is
This is in the miscellaneous case they have
Yes, my
filed.
lord. Miscellaneous
Miscellaneous
order.
No,
I have
151 petition. That
He
is
is right. I have also filed a separate 151 application in the execution. But this order is in the
This order is in miscellaneous case. So by abundant caution, they have also filed in execution.
page 40.
Page 40, yes.
He is right, my lord. I have also
40.
filed in that case.
Title
by
execution
abundant
case.
No, maybe, but this has been in miscellaneous case. This stay order has been in miscellaneous
That has
case.
been prayed for. Now, my lord,
That has been paid for, rejected.
rejected, but prayed for, my lord, in connection with my
I can do two
execution.
things. I can pass an ad interim order. I can direct you to appear. I can direct the injunction to be contested. then another round of litigation on injunction, then main case. That is one way. Or the other way around, leaving aside all this, I will direct the miscellaneous case. I will give you liberty to file an objection. Within a certain time, I will direct the miscellaneous case to be disposed of. You have a choice according to, if you want to contest the injunction, yes.
Now let me appear, my lord, with trial court, my lord, and my lord, can you limit it, my lord? Kindly limit it, my lord. Kindly give a specific date, my lord, within which, my lord, the trial court would complete the proceeding.
Yes.
Because, my lord, I have been, my lord, suffering for long, my lord. The person, my lord,
That's the
holder,
real otherwise, this will go on.
then, my lord, can you limit it, my lord? I am repeating, my lord, can you limit it, my lord? my lord, make it, my lord, 31st December, my lord, so that, my lord, at least, my lord, court will think, my lord, the situation is there, my lord. 1997,
Dr. It's-
I am languishing, my lord, since 1997, my lord.
I appreciate that, but it's difficult to fix that time. That is why I've given 30th of
Now, once your
September,
lordship, my lord, indicates, my lord, court normally, my lord, what we see, my lord,
December, then after December also has to be done. Then also liberty, it will, so that is why I've kept it at September. না কি বললাম নভেম্বর
November.
নভেম্বর
Grateful, man.
হ্যাঁ আবার কি আছে ডিসপোজড অফ ছাড়া with the above observations and directions CO number such and such stands disposed of.
Grateful.
Yes, I'm coming after 5 minutes.
প্রথম থেকে ফোন করেছি বাচ্চা ছিল এইটা দেখাতে হবে এই আরেকটা প্রিন্ট বার করে দে এটা স্যাম্পল হিসেবে পাঠাবো আরেকটা প্রিন্ট বার
Yes.
Not in a suit for eviction on the ground of only reasonable requirement.
Yes.
My lord, defendant filed one application for amendment for inserting some premises owned by the landlord opposite party, which my lord he suppressed in his plaint. My lord, so it is in a suit for reasonable requirement, it is expected that the landlord should approach the court in clean hands when suit is none other than the ground of own requirement.
Yes.
So, my lord, the ground of rejection is, my lord, 1 year back, my lord, plaintiff came to learn that the plaintiff number 2, that I mean wife of the plaintiff number 1, my lord, she acquired by inheritance from her grandmother one premises that was incorporated. And my lord, during the progress of trial, my lord, plaintiff defendant came to learn that another 2 house plaintiff acquired. My lord, so the defendant filed this application. Learned judge, though held that the event, it is not subsequent event, but detected subsequently. If I detected subsequently, my lord, the court can't bar the defendant to allow that amendment. My lord, it is the defendant who is seeking the incorporation of some new facts in the written statement, which to be dealt with differently. Well,
Where is your written statement?
yes, my lord, kindly see. First, my lord, kindly see my amendment of schedule amendment, page 36.
Yes, please
And
show me your written
yes.
statement first.
Yes, yes.
Page 18, your lordship.
Yes. Page 18. My lord, this is also amended written statement. When my lord first amended, my lord, the plaintiff number 2 acquired property that was incorporated in page 21. That is 1 Birchard Kosai Lane, paragraph, my lord, 10A. Page 21, paragraph 10A, that the defendant has come to know from reliable source that the plaintiff number 2, Srimati Chandra Das, is a
Where is your application for amendment?
Yes, my lord, this is, my lord, page 39.
39,
34.
34.
34, my lord, come straight away, my lord, 36. My lord, schedule of amendment.
34 is the AD card. Where is the application for amendment?
34.
Yes.
Annexed D.
Page. 34 is the acknowledgement due card. Property tax
Yes,
receipt.
34, 35. Yes, 30. Yes, 39, my lord.
39.
ও ভুল করেছে, এটাকে 39 কে 39 লিখেছে, 34 ভেবে পরেরটা 35 করে দিয়েছে। My lord, I'm sorry, my lord, this page is
39 is application under 151.
yes, that is amendment.
No. To put some questions, where is the application for amendment?
Lordship, there are 2 civil revisions.
My lord,
I believe your lordship is
kindly
already-
see, my lord,
There are
your
two.
my lord, 39,
two civil
40, 41 proposed amendment.
There are 2 civil division applications.
Yes, 13 also.
11 and 13. In one, there is a order 6 rule 17 annex.
And one, my lord, recalling.
Oh, so
In one order,
item number 13.
in
You have
one,
filed 2 civil division applications.
yes, in one, my lord, because in another application, my lord, I filed for recalling.
You could have filed, if it is by a same order, you could have filed. Like, where is the application for amendment? Show me that.
34, your lordship, item
My lord,
number 13,
My lord,
page number
my lord,
Item
39.
number 13, page number?
34. Order 6
34.
rule 17 application.
No, this is
No,
also
no.
AD card.
Order
What have you done?
My lord, 39, annexed D.
2454.
In 11, in my lord 11, item number 11, page 39.
That is also 151.
Annexed D.
No. Please check.
এটা ঢুকিয়ে দিয়েছে নাকি?
Do you have the copy of the amendment application?
Yes. My lord,
Yes.
kindly see, my lord, kindly see. This is my,
Look at this. Where you have
this is my copy, my lord.
in both the civil division applications, you have annexed 151.
আমি জানি দুটো করলেই গন্ডগোল করে দেবে। রিটিন স্টেটমেন্ট, হ্যাঁ পরেরটা পরেরটা
এবার 2454 টা কোনটা?
ও জানি না 2454 কোনটা জানি। 2454টাই তো আমি দিলাম। হ্যাঁ এই গন্ডগোল করেছি।
Where is the written objection to this?
No, no written objection. They accepted it, my lord. They accepted it. Only saying, my lord, since one time one amendment was carried out, when my lord, yes, এটা. But this is their, they admitted it.
Yes. So verbal objection was placed at the time
Verbal
of hearing.
objection.
The time of hearing. Your Lordship, on the earlier occasion, same point after commencement of trial that was made,
So,
that inheritance of property by the
yes, it is,
defendant.
Inheritance that has been made, but these properties,
yes,
what is your submission with regard to these properties?
same locality.
Whether there has been any proper due diligence that has been explained, whether or not that needs to be taken.
Sir, even if there is no commencement of trial,
Yes,
let
Your
us
Lordship,
Supreme Court
then
says, if it is
can-
necessary,
can
in a
be
suit for
allowed.
reasonable requirement, alternative accommodation, if you suppress, they
Yes.
can bring it.
Yes.
Can be allowed, but Your
Yes.
Lordship, they have to explain their due diligence in their application.
That is only your submission.
No, no,
It
no.
is-
That is one of the submission. Another submission, Your Lordship, kindly takes up the schedule of the amendment.
Yes.
It is not only regarding the additional, those two properties, Your Lordship will find in the schedule, after 1 and 2, the properties are mentioned, that the said properties are under occupation of the plaintiff still today, and after that,
No, I could not follow. The schedule of amendment, yes,
yes,
there are two properties.
two properties. After that, Your Lordship will find that the said properties are under the occupation of the plaintiff.
Yes,
Yes.
yes.
After that, Your Lordship. Furthermore, according to the deed of convenience, the plaintiff by which they have become the owners of the said building was two-storied at the time, but after purchase, the said building, the plaintiff further erected another.
Yes.
So there are two parts to this amendment. There's another part is construction. Now, Your Lordship, construction, whether they have been detected subsequently or not, that cannot be taken by, because if they had known that construction was taking place, they could have.
That will be decided at the, in
So,
the
Your
suit.
Lordship, that-
You prove that it has not no construction. It was there.
Your
This is
Lordship,
the alternative accommodation which they have sought to make.
Your Lordship, they can also produce their documents during their tender.
Are you disputing this? These properties, are you disputing?
No, Your Lordship, that is, but if Your Lordship, they can tender their documents from which they have discovered at that time of evidence.
Are you disputing that you are the owners of these two properties?
That I have to take it.
How can you shift burden to
This application under article. And what is the other application for? Yes, next 12.
But I'm for the plaintiff petitioner, but
Yes.
suit for damages and compensation. But in the suit, but though after receiving the summons, the defendant did not file written statement. After 1 year, when I file an application under Order 8 Rule 1, they come with a written statement. Now, the learned trial court, by an earlier order, accepted a written statement by observing that the learned advocate for the plaintiff consented to that. And in the said order, it is specifically stated that the Order 8 Rule 1 application is pending. Not a challenging that order, I came before this honorable court. Since the learned advocate plaintiff did not give any consent. This honorable court directed the petitioner to file a recalling application to the learned trial court. Well, if you also kindly first come to page 52, the first order,
Page?
52.
Yes,
This is order dated 11.
yes.
Today is fixed for hearing of
Just
petition under.
asking that, then what happened?
No, but I challenge this order. The next page is your lordship's coordinate bench order. Your lordship's coordinate bench granted me liberty, the page 54.
Yes,
But I filed an application.
yes.
Now, by the order impugned, the trial court rejected the application on the ground that since it's a suit for compensation, the defendant.
No, show me where have you stated that you have not made that submission?
Yes, madam. Can you see page 55, paragraph 3, 2 and 3? That the defendant in the instant suit filed a written statement after taking several adjournment on 16/5/2024 after an unexplained delay of about 522 days, which itself shows the defendant is not interested enough in contesting the present suit. The plaintiff stated that in spite of pendency of an application under Order 8 Rule 1 of the Court of Civil Procedure filed by the plaintiff herein on 12/10/2023, the instant learned court erroneously recorded bona fide by order dated 16 May 2024 that the learned advocate of the plaintiff consent to the acceptance of written statement subject to cost being paid to the plaintiff hearing, accepted the written statement filed by the defendant hearing. That challenging the order dated so and so, the plaintiff preferred a civil divisional application, which was subsequently, but I have given the detail. But 5, that till date the plaintiff have not received the cost. In such event, the plaintiff submit the learned court may recall the order passed by this learned court, recording that the plaintiff have no consent to acceptance of such written statement, even on payment of cost, and be further pleased to adjudicate Order 8 Rule 1 application of the plaintiff still pending on merit.
What was the delay in filing the written
All
statement?
more than 1 year. But they have received the summons. May I give you also the exact date when they have received the summons?
Mr. Ghosh, your application is, you have not stated that you have not, the learned advocate did not.
But in the
consent.
order passed by your lordship's coordinate bench, it is recorded.
No, not coordinate bench gave you liberty.
No,
Show me your application. And show me when you made submissions, that this was the submission made by the learned advocate. You made a wrong recording. This was not submitted. Show me that. No submission was made, Mr. Ghosh. Only one line erroneously recorded. Nothing thereafter.
Well, if I
The
kindly
learned advocate did not say that, did not take the responsibility. That learned advocate did not say, I did not do this. On the other hand, your prayer for recalling was that I did not receive the cost.
Well, kindly consider only one thing, just two things. My Order 8 Rule 1 application was pending.
Learned advocate should have taken a responsibility.
Order 8 Rule 1 application was pending.
Did he file any affidavit saying that he did not say that?
But that's not
Why?
that is not filed.
Why? How can the client say how that affidavit was affirmed? Mr. Ghosh, how this statement was affirmed that this was erroneously recorded? The issue was whether the advocate, because the earlier order, the submission was accepted. There should be.
That was.
So this submission that the learned lawyer did not make, where is that statement in the
That is
application?
not the reasoning before the learned trial court
Where is
rejected
your,
my application.
Mr. Ghosh, where is your application for that? That the court did ready to approach the learned trial judge. You did not take that chance. On the other hand, you avoided to make that statement on oath. And moreover, the client cannot say that in on affidavit. It's the advocate who has to say whether he made that submission or not. Yes, Mr. Ghosh, let me now pass the order. This application.
Can you see the application, the order impugned? But in the order impugned, the learned trial court rejected on the ground. But rejected on the ground.
Call the next matter.
13,
13 হয়ে গেছে।
14.
14. Yes, Mr. Sen.
Here for the petitioner, my lord, that defendants of the petitioner before the lordship, my lord, that suit for declaration and injunction, my lord, in that suit an ad interim order was passed. Against that ad interim order, my lord, an appeal was preferred. The short, so far as the first point is concerned, my lord, the ad interim appeal has been dismissed, my lord, directing that the order of the defendant is hereby restrained from disturbing the peaceful enjoyment of the suit property till the disposal of the suit.
I'm directing the temporary injunction to be disposed of.
But furthermore, my lord, there is a whole lot of suppression, my lord. Initially, a suit is filed on the self-same property by
Mr. Sen, I cannot stay this. No use will be served.
there is a caveat.
Your Lordship, I'm praying for not today as because we have
Caveat করে not
received,
today.
as we
caveat
have
করে not
received the, as we have received the copy yesterday itself, so 1 day accommodation is highly
Caveat means
solicited.
everybody should be ready with the
Mr. Sen, I am directing the
my lord,
temporary injunction application to be.
only for 5 minutes, my lord. My lord, suit is filed, my lord, against in the self-same property, my lord. In ad interim injunction granted, my lord, that ad interim injunction is vacated, my lord, by under a contested hearing. My lord, suit is not proceeded. Suit is dismissed for default. New suit is filed, suppressing everything that such suit was filed in the same property, my lord. Ad interim injunction is granted, my lord, and we
But-
prefer the appeal.
Yes, for that, Mr. Sen, you bring out those, or I can give you liberty to file an order 39 rule 4. But suppressing this order of injunction was obtained.
My lord,
If you say that, I can give you liberty to file order 39 rule 4, or if you want, file your written objection, take all points, it can be.
39 rule 4 be filed, my lord. Liberty be given, my lord.
This application
The petitioner herein before your lordship is a defendant in a ejectment suit, my lord. Ejectment suit has been filed by the plaintiff.
What is the impugned order?
Impugned order, my lord. I'm coming, my lord, just within 2 minutes. My lord, suit has been filed, my lord, against our predecessor. After the demise of the predecessor, we have been substituted. Now, my lord, during the pendency of the suit, my lord, the plaintiff, that means my landlord, did some renovation work of at his my lord, my tenancy is a commercial tenancy, it's a shop. During the pendency of the suit, my lord, without intimating he started some renovation work and some damages has been occurred in my tenanted premises. My lord, I applied before the court below that let there be repairing work, but at the cost of the my landlord, because my land due to the renovation work of the landlord, these damages has been occurred. My lord, learned court below allowed my application, but at my cost. And not only that, my lord, I applied for an application, filed an application or order 30 rule 7 for bringing a true picture of the suit property, that as only because that during doing this repairing work, if any question will be arises, then that will be meet up with this report of the learned commissioner. But unfortunately, my application has been turned down. And
You have been allowed to repair.
but allowed to on my course, you know, kindly, they have,
That repairing application has been allowed.
allowed.
Setting aside this, then first local inspection, then repairing. If your submission is to be accepted, so local inspection has to come first, rightly. So this repairing application has to be.
As you lost, as you lost,
You have been permitted. Why are you agreed by that?
I'm, Milord,
You do your repairing work.
my until this.
Where is your repairing application?
Milord.
Even if your prayer is allowed, you will come.
No, Milord, prayer has been allowed, but there are reasons.
Yes, yes. Tell me, give me what is the repairing work you want to effect?
Yes. Milord, at page number 33.
32.
33.
30.
And points for repair at 34. Milord, to get the crack of the side walls,
You restrict your work within that, there is no necessity. This application under Article 227 of the Constitution.
Milord, only one submission.
Yes.
Let the entire work be done under the supervision of For the petitioner in this matter, my lord.
Yes,
I have challenged several orders, my lord.
what do you want?
My lord, my appeal has been fixed for delivery of the judgment without hearing.
Without hearing?
Yes, and while the
Delivery of judgment.
yes,
So wait for some more time, you will file a second appeal if you lose. If you win,
sir,
it
I
will
can
come.
show from the order sheets that there has been no hearing held.
So that is, I think, a good ground. Don't press this application.
But kindly.
It's a good ground. 22nd of January. What is the next date fixed?
My lord, the next date fixed is, my lord, on 25th of August.
No, you are the appellant or the
I am
respondent?
the appellant.
Appellant, you are not hard.
My
So
lord.
it has to be dismissed for default then. If you are not hard being the
There
appellant.
was no hearing took place. This is my submission, my lord.
Yes.
From the order sheet, my lord, I can show, my lord.
Why are you saying that hearing did not take place on 18th of September? A order of stay was passed without hearing you.
Order of stay. No, my lord, the hearing in respect of the appeal has not been.
Stay application, you are hard. You got a favorable
Thereafter,
order.
thereafter, may I say, my lord, thereafter an application under Order 6 Rule 17 as well as 4127, my lord, was filed. Order 6 Rule 17 was allowed, my lord. Order 41 Rule 27, my lord, still remains pending, my lord. Kindly takes up once the order
Sir,
sheet.
you paid for adjournment on various occasions.
But may I show, my lord, the order sheet then, my lord?
Yes, yes.
Kindly once. But kindly takes up once, my lord. Order number 15, my lord.
The 13th of November, you filed a petition paying for time.
On 13th of November, my lord, I filed 2 applications, my lord.
This is also paid for time.
Yes, my lord, because my lord, I wanted hearing of these 2 applications, my lord. My lord, kindly takes up order number 15 once. My lord, the order 6 Rule 17 was, my lord, taken up for hearing on that date.
On 22nd of January, you
22nd
also
of
paid for
November.
time. You also paid
My
for
lord,
time.
my lord, may
File your written argument on
my lord, may I
22nd.
chronologically show the order sheet, my lord? My lord, once, my lord, may
You have filed the written arguments you have filed on 22nd of May.
yes, that has been directed to be done, my lord.
Yes. You have
May
done
I,
that.
my lord, may I show the orders once chronologically, my lord?
Yes.
My lord, kindly takes up once 22nd November, my lord. The date, my lord, on the, my lord, hearing of Order 6 Rule 17 and Order 41 Rule 27 was, my lord.
The learned advocate appealing for the petitioners.
Defend, my lord, 4 plaintiffs in while the suit was filed. But in the appeal, my lord, there's only one person, my lord. In it,
You have want to correct the cost appeal.
yes, my lord. 4 persons have been added. Instead thereof, only one will be there.
I'm appearing for the petitioner wife, my lord. I filed an application for alimony pending right, my lord, where the learned additional district judge first court Alipur directed the opposite party husband to pay rupees 12,000 for the petitioner and rupees 18,000 to the minor daughter, and the maintenance amount will be calculated from the date of order, my lord. Challenging that portion, I am before your lordship, my
You're
lord.
the wife.
For the wife, my lord. It's the impugned order, my lord.
By the order impugned, by the order. Get the balance. Yes.
Kindly make it in September, my lord. My humble request, my lord.
Yes.
Kindly make it monthly September.
Nothing will happen. Yes. Yes, Mr. Ghosh.
Application under Order 8 Rule 9 filed by the opposite party in a preemption case has been rejected by the landed court.
Why order 8 Rule 9?
For additional subsequent event. The plea was taken in the written objection that the mother and son, who are the co-sharers, the mother applied for preemption against the sale, and our specific defense is they have entered into an agreement for sale with other parties in respect of the same plot of land.
Mr. Ghosh, why not order 6 Rule 17? Why order 8 Rule 9?
For additional
In order to bypass the so.
That is practically, my lord, that is nomenclature is wrong, but subsequent event has been sought to be introduced.
It is order 6 Rule 17.
Yes.
So at what stage?
That is the PW1 has been examined.
So trial comments.
But lord, he for the first time he admitted that the property has been sold.
So rejected on what ground?
Lord, that is, he said that mother has no concern. Son has sold the share of the property. Joint family, mother and son inherited the property from father. Our specific plea is that the consideration money to deposit before the court has been collected by enter into an agreement with different person to preempt this sale. And Lord, subsequently, he has admitted the mother has taken money from other party and he has also sold the property to third parties, and that those deeds are also Lord produced before the court to show that it is connected with the preemption application. Kindly, my lord, see the impugned order. He has said that in the deed there is no indication that mother was there.
Where is the preemption application?
Lord, preemption application has been annexed. Lord, at page 15.
Page 9.
15.
No, preemption application, not the amendment.
Yes, page 9.
Page 9.
Yes.
Which is the impugned transfer? Which is the deed?
Lord, this is Lord 25th May 2022.
কত ইংরাজি দানপত্র মিলে So Dipali Maiti and Krishnendu Maiti,
yes,
they transferred.
Yes.
By a deed dated 25th of May 2022.
Yes.
In favor of Protipokho. Protipokho is Joy Prakash Manna. So Dipali and Krishnendu transferred to Joy Prakash Manna.
Yes.
And
Kakodi has applied for preemption under section 8 and 9.
Under what ground? On what ground?
Co-sharership.
Co-sharership.
Yes.
Which paragraph? Unprotected stranger purchaser. দাগ সমূহে শরিক হইতেছে।
Yes.
অগ্রক্রয়. So now, so where is your application under order 8 rule 9?
That is, Lord, page 23.
23.
Yes.
Now 23, what do you want to submit? তারিখে পেন্ডিং অবস্থা দরখাস্তকারিণী পুত্র 24 তারিখে সম্পাদিত বিনিময় পত্র মূলে No, Mr. Ghosh, what is the, what do you want to incorporate in the subsequent event, in the subsequent pleading?
Subsequent pleading, Lord, because he has actually transferred in the written objection.
Who has transferred?
Son.
How could the son transfer? Son of Kakoli.
Son of Kakoli. Lord, they are co-sharers. Jointly inherited from father.
Yes, but Kakoli, so Kakoli and Dibbendu.
Yes.
They are the co-sharers.
They are the co-sharers and there are other co-sharers also.
Yes.
Yes.
But Kakoli applied for preemption.
Yes.
So Dibbendu transferred.
Yes.
So how that is relevant with this? Even if the Dibbendu transferred, Dibbendu is another co-sharer. He has not applied for preemption.
No.
So how that is relevant in this?
Here, and you see my written objection, I have taken the plea that for the purpose of preempting this sale, Lord, they have collected money by entering into agreement from different persons and deposited in the court.
No, not they. Kakoli.
Kakoli.
So Kakoli, you have not.
They are in joint ways, Kakoli and son. And Lord, that has been stated and son has given deposed that in the meantime he has sold.
That is Mr. Ghosh. Mother and son.
Yes, Lord, I know.
Shares.
Yes, Lord.
Son may have transferred.
Yes.
Son may have collected. How that is relevant with the application of the mother? Mother has not transferred. That is not your case.
Mother has, can you see the evidence? Mother has also taken money from my father for sale. But can you see his evidence admitted? In the evidence from that, Lord, we have collected that there is a collusion. Everything has been done in collusion between mother and mother.
Deed, Mr. Ghosh, the deed mother has not transferred. That is not
That
your
is so.
case.
Lord, kindly paragraph 4. এই প্রতিপক্ষ নিবেদন করে যে
Paragraph 4, page
23.
Page 23, paragraph
এই
4.
প্রতিপক্ষ নিবেদন করে যে বাদিনীর একান্নবর্তী পরিবার সদস্যপুত্র দিব্যেন্দু দরখাস্ত জ্ঞাত সারে 823 3 ডেসিমাল ভূমি জনৈক মিহিরলাল দাস মহাশয়কে বাজার মূল্য 18 লক্ষ টাকা পণমোহর গ্রহণে।
Yes, this is with regard to the son, nothing with regard to the petitioner, Mr. Ghosh.
But kindly see, Lord, our case is not the son and mother in collusion with each other has collected money by taking advance from different parties.
I appreciate, but that you have not sought to. Here you have said only the son, not the mother.
But that is why I'm saying the son here during pendency has sold to third party. And mother has also not applied for preemption.
Mother has applied for preemption.
No, for
of that. The other one, that is a different thing altogether.
Yes.
Mr. Ghosh, that is a different thing altogether, whether
know.
mother has applied for that transfer or not. But here we are concerned only with regard to this. The mother has filed an application only with regard to that transfer of 2022 deed.
Yes.
And it's not your case that the mother has subsequently transferred.
No,
that is your case during the pendency. Mother has lost interest. That's a different thing altogether.
Lord, people are correct. Lord, that he is a sharer, he is right.
Yes.
He is right. But Lord, here our case has been made out that they are in joint means, they have jointly done it in the name of mother.
But
that is our case. This is not written objection.
Written objection, Mr. Ghosh, you prove it.
Yes.
No on that. But subsequent event, this subsequent pleading is only with regard to the transfer made by the son. Mother is not involved.
But in the original objection, we stated that the mother and son have collected money to preempt this one, taking money to different.
Prove that. You prove that.
But it is as a corollary. It will, my lordship can see that son has actually sold some property to those persons with whom the agreement was
yes.
in place. Lord, your lordship, that's why, Lord, it is just fact, additional fact
additional fact, what is German for the purpose of deciding, because Mr. Ghosh, it's effectively order 6 rule 17. So whether that is necessary. So here, what will be considered, whether that transfer was made, what will be decided in a preemption application,
What we have
whether the preemptor is a co-sharer or not,
that end.
whether this application, whether this transfer
Another-
was made to a stranger, and if that is proved, preemption will be.
But another aspect, your lordship, from another angle, the preemption is not the principle is to prevent fragmentation of land. But if it appears that the same other co-sharers have transferred the property to strangers, they have taken possession, and other co-sharers, mother including son, they have not taken any steps to preempt, it will be frustrated totally. But he cannot exercise his choice that a particular person I will sell and to a particular person I will not sell.
That can be done. All that you have to purchase everything.
Kindly consider this aspect of the matter. There are decision of this honorable court also regarding waiver and other things. Though not the prior to
that is prior, not subsequent.
No, prior to what that has been done cannot be taken into
subsequent.
But the subsequently, but
waiver principle will apply here.
Here we have in the written objection said what prior they have done and subsequently what
that nobody is, but this is Asun.
Well, this cannot be introduced by a subsequent event only.
Next matter. Item number 38.
But on the last occasion, Mr. Bhattacharya has concluded his argument.
Yes.
But kindly see the revisional application. But this revisional application is arising out of an order wherein, my lord, the application filed by Mr. Bhattacharya's client has been turned down. May I just remind your lordship the matter? To initiate proceedings, my lord, some documents has been produced before the special officer building by the private respondent. Now, my lord, that document is
Mr. Mukherjee, only a date has been fixed for hearing of the Section 5 application.
No. Or possibly, your lordship, my lord, this matter, your lordship, had on 3 occasions.
No. Lastly, Mr. Bhattacharya said that yes, he is ready. Initially, he said those representations were not made by him, but now thereafter he said no, he is not going to that extent. So only the cost, yes.
Now, my lord, may I just? I will take 5 minutes because, my lord, when the revisional application was filed, your lordship will find that there is a very clever drafting, my lord, that nothing has been stated that whether any other parallel proceeding has been filed or not. Now, a story has been made out, a submission has been made out before your lordship's court.
Mr. Mukherjee,
because
that is Mr. Bhattacharya now has made his stand clear. He is not going into that. He wants that this order that says Section 5 is to be heard.
I have no problem. But regarding cost part, my lord, I have something has to be stated.
What are you saying?
And if your lordship see a person who I have brought some judgment because it is from your lordship that I have to argue on the next day, my lord, I said I have brought some judgment. A person
for what?
Regarding a person who has come before your lordship's court is not in a clean hand, and the submission from the very beginning is that he don't.
Corporation is insisting on cost, Mr. Mukherjee.
No, the corporation may not. I will.
If the submission is made, my lord, then I will place all this.
I will. Let him. May I just 5 minutes? Let him make his submission.
He will not continue for 5 minutes.
The matter is going.
First, although there are certain judgments which I have brought, my lord, because from
for what?
So the conduct, because my lord, the submission was.
Mr. Mukherjee, I am not considering anything. Section 5, a date has been fixed. I will direct that Section 5 on the stay application to be heard on the next day. Whatever is there on merits.
Not on that, but how the proceeding can be delayed, this is a glaring instance because, my lord, when the Section 5 has been fixed for hearing, he filed an application stating that I found from the record that something has been filed before the special officer building which is not my signature, therefore proceeding has to be initiated.
Now he is not insisting on that.
Let him withdraw. Let him withdraw the revisional application then. He is challenging that order. He has not come up before your lordship court against Section 5 or any other. When
what do you say, Mr. Bhattacharya?
Argument.
I am. Today.
Are you really interested in that, or you are interested in getting your miscellaneous appeal heard out?
First submission is yes. I want my miscellaneous appeal to be heard out. The building tribunal appeal.
Yes, miscellaneous or the appeal. Yes.
Now, the thing is, my lord, on the other day, a lot of submissions were raised from the bar, as well as it fell from the court as to how I am enjoying the place, what is the sanction, what is etc. My lord, I am very sorry to inform your lordship, my lord, that if anyone is at fault, it is the corporation. Why? Because, my lord, here, though it is not a writ petition, it's a revision and application carried from a particular order. There is no doubt about it.
Mr. Bhattacharya, don't expand the scope of the civil revision application.
I am tempted.
On the last occasion, you said
I am tempted to. Why? Because, my lord, today I am tempted to show your lordship, my lord, the photograph of an incomplete building where my learned complainant, the complainant, my lord, my learned friend's client is deciding. The building is incomplete.
Nobody is stopping you. You take steps against that. Mr. Bhattacharya, nobody is stopping you from that.
A lot of things.
Mr. Bhattacharya, that is a different issue altogether. Nobody is stopping you. If you are entitled to, you can lodge a complaint, do whatever you want.
This is the sanction.
For what?
This is the sanction just to show the conduct. SOP has passed an order in a proceeding, in a lapse plan, in a lapse plan.
In respect of the private respondent.
No, in respect of this entire thing, including the order of granting regularization, including.
Mr. Bhattacharya, I am not going into that.
Your lordship will keep only this much.
No, but Mr. Bhattacharya, you have to say whether you intend to proceed with that contempt or not. If you are intending to proceed.
If the document which they seek
contempt.
Yes, yes.
40.
Seeking contempt proceedings and investigation against the
Yes,
municipal authority.
but in the nature
That
of
part.
340, it's a corresponding.
Are you intending to proceed with that?
I am saying that if the document sought to be relied on by my learned friend's client, not the corporation, then I have nothing to say. They are, in one of their pleadings to the Section 5 application, they have made a categorical averment, in paragraph 8 and paragraph 11 thereof, that, I have made certain representations. If it is not relied on by the tribunal independent of those, because I have complete reservations regarding the genuineness of those particular documents. I have complete reservations. Therefore, I insisted, I begged before the tribunal that please go into the veracity and correctness of these documents, which the tribunal declined to do and imposed costs. If that is not relied on.
So, Mukherjee, what do you say? If he is entitled to, I will segregate this part.
No.
That cannot be tagged with this. If he has a case, let him proceed with that.
Kindly see the writ petition, page 18. In the page 18, he himself filed an application before the corporation saying that I have done this regularization.
But he says that the representation which was, that is not by him. He is not saying that he has not filed.
I will not see what I will do. I will see whether there is any sanction plan. If someone has made some unauthorized construction, now I have to decide whether the order of the special officer building is right or wrong. I will not, because my scope is very limited. I can't go beyond the same. Number what I have done by the impugned order, I said if you want to initiate proceeding, you do. Why me? Kindly see the last part of the order.
Yes.
Kindly see.
I don't think my learned friend is not defending the complainant.
Why
he is for the municipal authority.
He is saying every day this thing. But
Yes.
kindly see the last portion of the order.
Yes.
But 25th April.
25th.
April 2025.
Yes, 25th of April.
That the petition filed by the appellant seeking contempt proceeding and investigation against municipal authority and private respondent today is rejected. The facts numbered, kindly see the before that. So far as the question of forgery and fabrication of the said document is
Where is the contempt application? Where is the contempt petition?
That is
Has
page
it been annexed?
54.
Page?
I'll just give you a note. Now it begins from page 52. In page 54, at page 54, paragraph 7, this is what I have treated.
contempt of court under section 379B.
Mr. Mukherjee, where is this document of 14th of March? Is it in your records?
It is in the record of the BT file.
In the BT. Madam, kindly see what is his statement. Madam.
Page 54, paragraph 10.
Page 53.
Page 53.
53, paragraph 4.
Yes.
That during the course of hearing, an objection in the form of affidavit has been filed by the added respondents, objecting the application of a condonation of delay filed by the appellant. That the said affidavit is filed by the private respondent before this tribunal.
No, Mr. Mukherjee, please come to page.
I will come. But
paragraph 10, that is the paragraph 7 is the first. Inspection of the case record was shocked to see a representation has been served furnishing various title deeds of the purchased property. Admission was made admitting that the appellant has committed illegal construction.
May I just show you, Your Lordship? Before that, kindly conjointly read paragraph 3. It will clear before Your Lordship's court.
Yes.
That during Okay.
Where is this representation? Do you have a copy of that?
Representation, my lord, I am the authority. He filed an affidavit. In the affidavit, those document has been annexed.
No.
Kindly see the petition.
It was just award.
Mukherjee, where is this? Please kindly come to paragraph 10. The representation addressing the special officer building is a
14th
false
March.
by 4G. Yes. Where is this 14th of March 2022?
But that may be with the building tribunal. That with the building tribunal.
Yeah, that's the case record before the building.
That is the case record before the tribunal.
And the opposition.
You have a copy of that, Mr.
But
Mukherjee.
building tribunal record we can't, because my lord, I am not appearing on behalf of the building tribunal, because
No.
my order is under challenge before the building tribunal. I cannot.
Records have been sent to the building tribunal. It is with you. Has the records been?
That I have to.
Mr. Chatterjee, my lord, with me, my lord, he says it is lying with the SOB's office. Special Officer Buildings Office.
Please, Mr. Mukherjee, please take instructions whether the representation is there. Please bring the representation. And Mr. Bhattacharjee, if I find that it is by your,
I'm taking that risk.
you'll have to face.
The first day, same thing happened. Kindly see the first day.
You'll have to face
No,
consequences.
no, I'm taking the.
Kindly see the first day order. Kindly see the first day order. Every day new argument and everything. Kindly see first day's order.
First day's order.
First order passed by your lordship. Kindly see once.
Yes.
Now kindly permit me to place my case in my own way. But kindly see the order date 24th June.
Yes.
Now on 24th June, when the matter was taken up, Mr. Bhattacharya argued he don't know anything. He never participated. He never filed any application before the corporation for regularization. Then when I pointed out before your lordship, there is a clear suppression of material fact that on the self-same cause of action, a writ petition has been filed. In the writ petition, my lord, he has filed an application, my lord. Kindly see the writ petition. Once, my lord, page 18, he himself has admitted he has done this. Kindly regularize. Now, on that day, your lordship said that if I found that it is on self-same cause of action.
Bhattacharjee, one thing. According to you, you have not issued a representation of 14th of March 2022.
My lord.
But you are not denying
Please.
that subsequently you have applied for regularization.
That, yes, I cannot.
Not that, 16th March.
Subsequently, you have applied for regularization. So the fact remains, it is admitted by you that there is some illegal construction for which you want regularization. That's the fact. Even the representation is eschewed from that. So fact remains that you have
So that is 14th March. My lord, he is saying 14th March. This is 6th March. Prior to that.
No, 14 March 2022. This is 6 March 24. Not prior.
2024.
24.
So
No,
even
but
if that is eschewed, Mr. Bhattacharjee, admission of that
I am
remains.
taking that risk. Prepared to take that.
What risk?
You know, the thing is, I made this submission, categorical submission, and I stand by that, my lord, in the teeth of pendency of the BT appeal before the corporation, my lord, the writ petition or any representation made in furtherance to any intention to get it regularized perhaps does not survive, because the tribunal appeal is the actual forum. The tribunal is going to decide the entirety of it. Even if I have made a representation rightly, wrongly, I am bound by the representation, but definitely the corporation is not obliged to consider the representation. My lord, the writ petition was merely presented as an abundant precaution, which I have also indicated that, my lord, it is not very good practice on the part of my client. I have also advised Mr. Chatterjee to withdraw the writ petition. And in fact, my lord, steps have been taken to get it withdrawn, the writ petition.
Withdrawal, Mr. Bhattacharjee.
Remains. The representation remains.
Admissions also remain.
100%. I stand by it. Now, my lord, the thing is, today, your lordship is looking into an order made by the tribunal in a proceeding arising out of a appeal filed, my lord, concerning a SOP's order. Before the SOP, it was contended by my learned friend, Mr. Mukherjee, my lord, appearing for the private respondent at page 46.
Mukherjee.
Shaudhya Mukherjee. At page 46, my lord, kindly sees.
Of this civil division
Of this
application.
divisional application.
Yes.
In connection with the section 5. That
Yes.
several complaints were lodged with KMC authorities regarding unauthorized construction within the said property, and the same were duly considered, and in reference thereto, such and such after providing a right of representation to the defaulting parties and hearing the concerned parties, the order dated this has been passed. Now, Milord, after providing a right of representation, Milord, read with paragraph 11.
Yes. Yes.
Milord, precisely it is paragraph 8. I'm sorry. It is precisely paragraph 8. Now, Milord, my learned friend who was appearing for my client, Milord, before the tribunal, he thought to inspect the records. In this, Milord, affidavit, this document is not appended. Nothing is appended. Apart from
But according to you, that is lying in the office of the
office of the SOP.
Mr. Mukherjee, please bring that.
I will kindly see. He
Please bring that.
I will. What is his intention? Just to delay, my lord.
No. I'm making it clear. Where is the next date?
Milord, August 21st.
21st of
August. No, not only that.
I'm making it clear that pendency of the civil division application will not preclude.
But what happened? What we learned? They have already issued a notice of contempt. Now, my lord,
For what?
we are not taking any steps.
Who has issued a contempt?
But the private respondent has already. Now, my lord, kindly see one thing. Kindly turn to page 5, paragraph 6, revisional application. Kindly see once.
Yes.
Milord, just
page 5, paragraph 6.
This is the nature of the building.
But this is the way, not
Page 5, paragraph 6. Yes.
Let either Mr. Bhattacharya complete the argument. Page 5, paragraph 6.
Yes.
But he himself stated he attended in the hearing. Kindly see.
One paragraph.
Subsequently, petitioner make himself present before the hearing and attended the hearing on the said date and sought an oral prayer for regulation and change of user. What remains if I say this question to myself? Initial case was that he don't know anything. Suddenly he came to learn everything. Now, my lord, what happened? What the building tribunal, the chairman will do? Chairman cannot, my lord, identify.
Where is the order of the SOB? Page.
But page 36.
What was the date of hearing?
4th November.
4th of
November 2022. 4th November 2022.
Where do I find the date? Oh, 4th of, yes, date of hearing. 4th of November 2022.
And they have received the notice on.
No, this is the hearing of 23rd of May 2022.
Now, what is his case? He says he attended the hearing. Initially, what is, kindly remember, my lord, initially what is submitted. Now, my lord, initially the submission of Mr. Bhattacharya, he don't know anything. He is one of the co-sharer. He suddenly came to learn that a proceeding has been initiated. Then and then he came up before this court. Kindly see the order of this court. This honorable, but kindly see once. But if I put this question to myself, can the chairman building tribunal decide whether it is his signature or not? He has nothing to do. If the document has been filed by something, liberty has been given to him. Kindly see that order. Kindly see. But this order has not precluded my learned friend client to take in steps. Kindly see once, minute. The question whether fraud or misrepresentation was committed with respect to the said representation dated 14/3/2022 should have been raised before the special officer building before whom the said document was submitted. This tribunal is empowered to hear the appeal under section 403 of the KMC Act, which was preferred to challenging the order of the municipal commissioner passed under section 401. The next date has been given. Now he can take any steps against that letter. Municipal building tribunal chairman cannot take any steps because it is not his case.
Yes.
Now, kindly visualize the thing. When he initially filed the revisional application, what is his stand? Kindly remember the submission. He stated he don't know anything. He is one of the co-sharer. He purchased the property. He don't know anything. And for that reason, what happened, when the corporation came to demolish the portion, he then and then filed the he filed the appeal, but this honorable court permit him to prefer appeal before the tribunal. This is not the fact. Kindly see the order of the division bench. Before the order of the division bench, the division bench did not entertain the matter because he has already preferred the appeal before the building tribunal. That's why division bench did not entertain, but the submission was made as if division bench permitted you to prefer the appeal. This is not right. Second thing is that, my lord, kindly visualize, my lord, what happened, my lord, when the first hearing was taken place.
So Mukherjee, the appeal is to be heard. Section 5.
Right, I have no problem.
I'm directing that. So let it be heard.
Appeal, my lord, section 5, my lord.
Section 5 and the stay. Yes,
Because
yes.
my section 5, all my amendments will be going, my lord.
Yes. Yes, who is appearing? Yes, Mr. Chatterjee.
May it please your lordship, Lord. Lord, the defendant numbers 2 to 6, appellant, Lord, is the petitioner before your lordship. Lord, in a suit for
Defendant number 2.
2 to 6.
Yes, suit for
Declaration, my lord, that the school, who is one of the parties, my lord, not the party, that the school, who is a third party, has a right of irrevocable license. In such a
What is the impugned order?
in such a suit, an application, the revision application is directed against an order, my lord, where an injunction has been granted ad interim by both courts. Now, on the ground that the school has come forward and will not put forward its case. Will not a third party who's got nothing to do with the suit, with the school, has filed a suit, will not, saying that the school has a right and I don't have a right. Kindly looks to page 23 once.
Yes.
Just looks to the prayer first, rather, not, it starts from 23, looks to
What
30.
happened to the temporary injunction application?
Lord, they have now filed, they have stalled it. They have now filed an app. They have stalled the hearing of the temporary injunction application.
Why?
They have filed an application under Order 1, Rule 8, asking the school to be, my lord, made a party there. My lord, I am not even going to get into that. On the basis of their own averment, I will show, my lord, that they don't have a right in the property for which there has been an infraction and a suit lies. On the prayer itself.
Mr. Chatterjee, it has to be hard.
My lord, gives me 10 minutes, I'm showing your lordship.
Mr. Chatterjee, it is to be hard. Cannot be a motion stay.
10 minutes, I'll show your lordship. I don't think it needs to be heard. Kindly looks into it just to the plain. I'm not going to show anything else.
When is the application for temporary injunction?
The temporary injunction is passed on the ground, my lord, as if the school is the plaintiff. On the face of it. On the face of
the temporary injunction application.
Now Order 1 Rule 8 years on. I'm heavily pressing this revision application.
Yes.
Because I'm not even going to get into anything else.
Fixed, 10th August.
They will want that. Kindly looks to page 30. It's a different
Page
thing.
30.
30.
Yes.
Have a look at it. I am placing this prayer before your lordship.
Yes.
A degree declaring that the suit property which is recorded as Onumoti Dakholikar in the Khotian permissive possession, being the suit property mentioned in the schedule below, is the property of Khamarpara Jagriti Hindi Vidya Mandir, and the same has got permanent right, title and interest, and the license Onumoti has become an irrevocable license. Who is the plaintiff? Kindly comes to page 19.
Yes.
Kindly sees Khamarpara Social and Educational Welfare Trust having its principal office at Southern Search.
Yes.
And this trust has got nothing to do with the school, which your lordship will find at page 29.
Page 29, yes.
29. But kindly from the top, could not take steps against such attempts by the defendants in collusion with the pro forma defendant and the plaintiff number 1, which is founded and formed with one of its main goal for upliftment of education, including establishment and maintenance of schools, formation of colleges, etc. The plaintiff number 1 and the other plaintiffs who are directly related to school affairs cannot sit idle against the evil design of the defendants in collusion with the pro forma defendant number 7 to forceful possession and acquired a part of the front portion of the school premises being suit property herein, and the plaintiff number 1 and the plaintiffs who are directly and indirectly interested in the welfare, development and proper functioning and for protection of its property and boundary have locus standi to file the instant suit for appropriate things.
Yes.
My lord need not go even one step beyond that. Looks to the impugned order. Kindly turns to internal page 6.
Trial court or the appeal court?
Appeal court. Trial court, my lord, has quoted the appeal court has quoted the trial court.
Yes.
Looks to internal page 6. My lord, sees the third paragraph, my lord. Third. It is also found that in the impugned order, my lord, got it? The trial court has made the following observation, and it's based on this that, my lord, the appeal is disposed of.
So this is the trial court order
Trial
which has
court's
been
order. Yes,
quoted.
my lord, quoted. That's why I did not trouble my lord with the trial court's order. On perusal of the documents produced and considering the submission made by the learned advocate, it prima facie appears that the plaintiff's school has been recorded, kindly marks it, plaintiff's school. It has been recorded permissive possessor in respect of the scheduled property in RSROR as well as LRROR in respect of Khotian number such and such, and there also exists a trustee dated such and such in respect of the plaintiff's school. There exists a strong prima facie case in favor of the plaintiff's school. This trust deed has got nothing to do with the school at all. It's just been named as a trust. Somebody, not an interloper, he comes and files a suit, saying that I want to do it for the welfare of the school. This is a civil right. This is not a public interest litigation. And the court is passing an injunction on the ground that the school has come forward.
Yes.
And it's based on this paragraph, that the injunction is granted. They failed to see, that the school has not come forward. Now, kindly looks to the order 1 rule 8 application.
Has been annexed.
No, my lord, it is filed later.
After.
Later. Have a look at it. I just have one copy, my lord. Just have one copy. Kindly see the prayer. And it's a order 1 rule 8 application. Kindly marks that. Had a copy, yes. I just have one copy, my lord. I'm sorry, I can't place it for your lordship's consideration.
Yes.
Sees the malafide. Sees the question whether this trust has a right to file the suit.
Anything more?
Nothing.
Yes, Mr. Chakraborty.
My lord.
Who has filed the suit?
Yes, my lord, fine. First, my lord, is Kamarpara School and Education. My lord, I'm referring, my lord, the plaintiff, my lord, page 19.
Yes. Who is the plaintiff?
Yes, my lord, Kamarpara Social and Education and Welfare Trust having such and such, my lord, is represented by first Dinonath Prasad, son of such and such.
Yes.
Second, my lord, second is Rajnath Yadav. The next page, my lord, kindly see. Gaurhari Pradhan, son of late Bankim Chandra Prasad, residing on such and such. My lord, here, my lord, and thereafter, my lord, that is one, my lord, the plaintiff number 2, Dadon Jadov, son of late Lakshman Prasad Jadov, guardian representative of the present committee. Guardian representative of the present committee of the Khamarpara Jagri Hindu Vidya High School, residing at such and such. Next, Bhagavan Chaudhary, son of late Ram Chaudhary, residing at Ato.
Who is the plaintiff?
My lord, these are all plaintiffs.
No, I am asking you who is the plaintiff?
My lord, kindly see. My lord, the next page, my lord. After my lord, next.
So whether the school is the plaintiff?
My lord, the guardian school, my lord, here, my lord, the guardian of the my lord, he represent.
Who can represent the school?
My lord, kindly see.
Mr. Chakraborty, who can represent a school?
My lord, school can be represented by the committee.
Which committee?
My lord, committee, my lord, there is
which committee?
No election has been made. That's why, my lord, kindly see.
So anyone can form a committee and can represent.
That's not. Kindly see. The plaintiff number 2, Dadon Jadov, son of late Lakshman Prasad Jadov, guardian representative of the present committee.
But Mr. Chakraborty, show me the trial court proceeded on the basis that the school is the plaintiff.
Yes, my lord.
Show me that the school is
my
the
lord,
plaintiff.
Thereafter, my lord, order 1 rule 8 application has been filed.
Let it be proceeded.
My lord, no, kindly see.
Proceed with the order 1 rule 8.
No, my lord, order 1 rule 8 application, my lord,
yes,
can be filed even at the appellate stage. My lord, I am going.
Do that. Nobody is stopping you from that.
So, my lord,
do that.
My lord, this is a suit for the interest of the school. This is
who is taking interest in the school?
Public is interested. Public. I am also one of the member of the public. I am also member of the public because I am at the one hand, I am a representative of the guardian.
Let that application be first considered.
No, no, my
Thereafter,
lord,
injunction will be considered.
Here, my lord. Prima facie case, whether I have court has.
School is run by the trust.
No, no. My lord,
How is the trust related to this matter?
trust.
How is the
My
trust the plaintiff?
My lord, leave aside the plaintiff number one. Leave aside plaintiff number one. My lord, plaintiff number two. My lord, kindly see. Plaintiff number four is.
Number two is not.
They are the trustees of this trust.
No, no, plaintiff number two is not the trustee, my lord. Kindly see. Dadon Jadov. My lord, kindly plaintiff, page 20. Page 20, my lord, kindly. Dadon Jadov, son of late
Yes, Mr. Chakravarti, the identity order has been passed, totally misconstruing the misconstruing the case and setting it aside. So
kindly see, my lord.
and directing the temporary injunction to be heard.
No, no, my lord, kindly see. What will remain, my lord? My lord, my possession.
Many things will remain.
My possession will be no, my lord, kindly see.
His possession.
Guardian representative. Guardian, he is part and parcel of the school.
Who says? Show me the authority. They are the guardian representative of the school. Show me what document you have.
Guardian representative of the parent.
Mr. Chakravarti, you are saying some persons are the guardian's representative.
No.
Show me how have you stated how they were elected, when they were elected.
When committee is granted, committee is.
Show me that.
Well,
What is the documents, Mr. Chakravarti?
Just, my lord, I'm trying to, when committee is formed.
When it was formed, when this committee was formed, what have been stated in the plain? When this committee was formed, it was valid till which date? Show me your averment in the plain. Nothing has been stated. Nothing has been stated.
Committee when
your locus to file this suit.
Yes.
Please satisfy me from the plaint.
My lord, just I am trying to place certain judgment, my lord. My lord, kindly.
For what proposition, Mr. Chakravarti?
Position that, my lord, order 1, rule 8 is a curable defect and it can be made at subsequent stage and that will not affect the merit of the suit. So, my lord, here
I am not dismissing your suit.
Yes.
I am not dismissing your
suit. My lord, if I am a member of the public, if I am a member of the public,
the court did not proceed on that basis. Mr. Chakravarti, court did not proceed on that basis.
My lord, the substance of
show me that the court, what is the ground on which this order of injunction was passed?
Substance of the case is that it is for the benefit of the school.
Mr. Chakravarti, show me the court's order.
My lord, kindly see.
On what basis this identity order of injunction was passed?
My lord, kindly see the pair of the plain, my lord.
But even if he's a member of the public, it's a private individual's right. It's just.
My lord, kindly see what is the prayer, my lord. A degree, page 30, a degree of declaration declaring that the suit property is recorded as Anumoti Dakoldar in the Khotian such and such being the suit property mentioned in the schedule below is the property of Khamarpara school. I am not claiming for myself.
Exactly.
My lord,
Also, this application under Article 227
kindly make some observation. I have,
But
I have filed
I've
application.
said in accordance with law.
According to law, the very broad thing.
Mr. Chakrabarti, I've only set aside the ad interim order.
No, my lord.
Temporary, I have not rejected your application for temporary.
My lord,
That remains.
Order 1, Rule 8, but some, my lord, touch my Order 1, Rule 8.
Order 1, Rule 8, expeditious disposal.
Not
That I can direct.
Kindly directs.
That I can direct.
That directs.
কি বললাম? Yes, 273, who is appearing? Yes.
I'm appearing for the petitioner, my lord.
Yes.
Lord, in a suit for injunction, simplicity of, an application under order 1 Rule 10 was filed. After 20 years of passing, the suit is of 2004. In the year 2024, an application under order 1 Rule 10 has been filed for addition of party.
What is the suit for?
Suit for injunction. Lord, plaint is at page.
Where is the application under order 1 Rule 10?
Takes up page 87.
You are for the opposite party? Added opposite party. Page 87.
Lord, plaint is at page 20.
Plaint at page 20.
Yes, my lord.
Yes.
And my lord, at page 32, ad interim injunction was passed.
Yes.
Their written statement is at page 70, my lord.
Whose written statement?
Their written statement in the injunction.
No, he is the added party. He has not filed a written statement.
Yeah, sorry. He has filed an application under order 1 Rule 10.
What is your plaint case? Why have you filed this suit?
2004 at
Yes, yes. What is the cause of action for this suit?
The defendant was breaking at the structure which was standing at the suit.
Who is the defendant? He is your tenant.
No.
So
he is not my tenant. He is not my tenant. He is the owner of some other dog number, which is adjoining. Though presently they are claiming that, my suit is
Suit
that.
property is one tile shed room.
Yes, my lord.
Yes. Yes, Mr. Chatterjee, how are you an interested party?
In their application under Order 1 Rule 10, they are claiming that they are the owners, they are the brothers of the, or the co-owners and co-sharers of the defendant. They have submitted the genealogical.
Yes, Mr. Chatterjee.
What happens to sharer with that the allegation in the plaintiff that there is a construction going on by demolition construction. What is it? Now, my lord, we use the written statement, my lord, where it is stated.
You have not filed a written
For other question. There is a written statement, my lord, where it is stated categorically that the plot is the other plot or adjoining plot, where my lord, there is a development issued by my lord, all the co-sharers in favor of a developer and a construction is going on. Now, apropos this, my lord, a writ petition was taken out by them. My lord, where my lord, they added me at a party in the writ petition seeking the unauthorized construction with respect to the self-service.
Mr. Chatterjee, that is a different thing altogether. That is a different cause of action. Unauthorized construction, even a neighbor passerby, they can file. That's not here. Here is a case.
Whether I am a necessary party or a proper party.
How are you a necessary party? If you have a remedy against the plaintiff, you file your suit. Nobody is stopping you from that.
Now the issue is that after written statement, both the plaintiffs, with regard to the identification of the food plot. Now, my lord, he says the food plot, if my lord sees the schedule, he says that dark number 235,542 is the food plot. We say the dark number is 230, not 542.
Mr. Chatterjee, that unless you are added, then this dispute cannot come. How are you a necessary party? Even if you are an owner, even if you are an owner of an adjacent plot, can you become a necessary party in this suit?
In the suit, they say one of the portion to be trespasser.
Yes.
But the trespasser saying
that co-sharer will take care of. So he is not, Mr. Chatterjee, none of your rights are affected because you are not a party.
Just give me a moment. The development agreement which is been there, is also given by me, one of the co-sharer. So my construction is now being stopped at the behest.
How? There is no Mr. Chatterjee. No, there is no injunction against you. There is no injunction against you.
Question.
Mr. Chatterjee, the injunction is against the party.
Yes.
So you are not bound by the order of injunction.
Simplicity that the party is listed, it's no construction.
Injunction operates against a party.
Yes.
So if you are, do you mean to say, even if you are not a party, you will be bound?
Not because my development agreement is an issue.
You construct, nobody is stopping you from that. No, not a question of, Mr. Chatterjee, not a question of clarifying. So if you are not a party, then any order of injunction cannot bind you. That's the settled proposition. So
they will say that property is there.
That remedy, Mr. Chatterjee, if you find any threat, so you can very well file a suit. Nobody is stopping you. Nobody is stopping you from filing a suit. Because here, Mr. Chatterjee, the suit property is only a tile shed room. And what is your?
That's why there is a development there to develop that property. Kindly takes up the plane for once. Kindly takes up the plane for once. Why can
Yes.
become a necessary party now?
Yes.
Now, kindly see paragraph 3. Kindly see, they say that earlier one, Hon'BLE Day. Why not finding paragraph 3 of the plane?
Yes.
The father-in-law of the defendant. Now, Hon'BLE Day is my predecessor.
Yes.
And my lord, my sister's husband is the present defendant against whom only chosen to file the suit.
Yes.
Now, my lord, in this, they say there was a previous suit in respect of this suit. There was a declaration against Hon'BLE that he is not the owner of this plot. And now, my lord.
Sir, Mr. Chatterjee, by way of addition, the scope of the suit cannot be expanded, enlarged. That's the settled process. Now, please take up what is the cause of action of this suit.
Yes.
The cause of action is after the date, paragraph 4, after the date of the father-in-law, the defendant trespassed. So this is the cause of action. So whatever you have, development, do that, proceed. Nobody is stopping you from that. So it's a permanent injunction, trespassing. So this is the cause of action. Mr. Chatterjee, by way of addition, where is that judgment? You have not brought that
Yes,
judgment.
my lord, at page 35, and relevant page is 40, my lord.
I'm not asking of this Supreme Court judgment. By way of addition, whether this can be enlarged. You have not brought that.
Kindly take a written statement, whether I'm enlarging the scope or not, kindly see.
Written statement is not by you.
Maybe, but.
Let your co-sharer, Mr. Chatterjee, let your co-sharer fight it out. You cannot be said to be a necessary party in this suit.
Now, kindly take up for once. Why I say this is no enlargement. I'm not getting added in a suit. I'm not enlarging the scope. Issue of this suit should be between the pleadings.
What is your contention in the suit? What will be your contention if you are added?
My contention would be that I am one of the heirs of Howell, and the suit plot is part number
So you are the owner of that plot.
owner of that plot.
So now your title will have to be decided. Your title will have to be decided. Then you have entered into a development agreement with certain other parties.
Can you visualize it? Not only that. The issue is the identification of the plot. He himself says that's an adjacent plot. I am the owner. Now, he says in the adjacent plot, the question of demarcation comes in. If I am not added as a party, in demarcation.
Mr. Chatterjee, what is your holding number?
My holding number is kindly takes up
Please tell me the holding number. What is your holding number?
213. Card number 213. Holding number 427. Previously 318.
51 previously?
318. That is
no, earlier holding number is 427.
No, present holding.
And present holding is 897. And your holding number is?
My holding number is?
Yes.
3213.
3213.
No, 213. Card number.
So it's different.
It's different. Adjacent. So
Maybe adjacent.
Identification.
Yes. Identification. If there is a dispute, you file a suit against. Yes.
My lord, this is a case of a very unfortunate person, my lord, who suffered a motor accident, injured in a motor accident in 2005, my lord.
What is
Thereafter,
the order under challenge?
my lord,
What is the order under challenge?
order under challenge is the first page of the impugned order. Two orders under challenge, my lord.
Yes.
One is 19th August 2024, which affirmed the order dated 1st December 2011.
What is the order dated? Impugned order dated?
Impugned order stated, my lord. Here, my lord, 19th August 2024. This is the
19th
first
of
page of the
August.
certified copy. Third page of the certified copy, my lord. If my lord,
Third page of the certified copy.
certified copy. First is the after petition, there are annexed, thereafter certified copy. Certified copies, my lord.
Order number 45, my lord.
Has my lord got it?
19th of August.
19th of August.
2024.
Another is, there are two orders. Another is order number 11, 1st of December 2011.
Which is after few pages. 1, 2, 3, 4, 5, 6, 7.
1st of December 2011.
2011.
Let me go. Please give me a minute.
My lord, the case has a little bit a prolonged history, my lord. So, may I have the pleasure of your lordship to just point out the outline of the case, my lord, so that it will be helpful, my lord.
Yes, the plaint was rejected.
Plaint was not rejected, my lord. It was, my lord, it was the innovative and, my lord, spectacular fraud committed by the insurance company, my lord. Kindly come at the page 14, my lord. Their contention.
The order dated 1st of December 2011. The MSCC case was dismissed. If you say that it is not rejection of plaint, so if it is dismissal, your remedy lies elsewhere. Cannot be by way of a civil division application if the MSCC case has been dismissed.
It is
and thereafter you have filed an application for recalling.
Recalling.
Yes, how can it be recalled? How can it be recalled? What is the ground for recall?
My lord, it is not rejection, my lord, after all. My lord, it has been rejected.
Sir, ordering part is rejection. What is more? MSCC is rejected. Either plaint rejected or on merits rejected. So it's not a revisable order, sir. And the last order, 19th of August, says that order rejecting is an appellable order. 151 is rejected. Ashun, this application under Article 227 of the Constitution of India is at the
Pending, that was the.
That is a different thing altogether.
My lord, 7 my lord, since my lord, motor vehicles rules my lord also says that it is with the order summon rule level not applicable my lord, then I am remedialess my lord. Power vested in rule 342 my lord.
Order 7 rule 10 is applicable, not order 7 rule 11.
Power vested under
Yes, Mr. Bhattaji, what do you say to this? Order 7 rule 11 according to him, rule 343. Order 7 rule 11.
342 my lord.
342.
342 are the power vested in which may be exercised by the claims tribunal. So 342, the only powers the motor accident claim tribunal can exercise are the powers under 342.
343 also says the following provisions shall apply. 343.
343.
Yes.
Order
7 rule 11 is not there. Order 7 rule 10 is there.
Order 7 rule 10 is there. That's
Yes.
time this question also happened at the time of admission. While that I since it was I was anxious for hearing getting the matter hard. While that I missed out it went out of.
What do you say to this?
Two things, my lord. The claim application was rejected since a different proceeding was.
He says that that proceeding is not pending. That there is no proceeding.
That was at that time it was not pending. They palpably made a false submission. My lord, they kindly come to.
No, I could not get you. At that time, it was not pending.
It was not pending.
What happened to that?
Prosecution without any liberty.
Oh, you have not pressed that.
No, it was not. It was for want of court fees, my lord. Not payment of court fees.
Page 14.
The above case has been dismissed for want of prosecution on as well as non-payment of court fee. Page 14, 1-4.
And order 9, those provisions are also not there.
So,
order 9, which provisions are there? No, order 9 is there. Non-payment of court fees.
Dismissed for want of prosecution on 9 February 2000.
So what happened there? The summons was served.
Yes, we have received the summons.
You have appeared.
Yes.
My lord, let them put it on record, my
What?
lord.
You put it on record. Why they will put it on record? You have obtained, you have, it was dismissed for non-prosecution. You are saying that was not pending. It is you who have to show that.
My lord, it was my lord with my lord get me before non-suiting me, my lord dismissal. My lord, this is a my lord what I humbly beg, my lord.
Please
Since
once
my lord,
please produce the records. The plan.
My lord.
Yes.
Lordship, annexure E of the petition, Lordship, page 62.
Which is the order under challenge?
Order under challenge is at the very end, 14/11/2024.
Where is the mediation report?
Lordship, the mediation report, the original one is in the other file.
Who has filed the matrimonial suit number 210 of 2020?
210 was filed by the petitioner.
Petitioner, have you withdrawn that?
We have not withdrawn. They had placed the settlement.
You have not withdrawn, they have also not withdrawn.
Lordship, it is dismissed. It is dismissed, not as withdrawn, but dismissed on the basis of
210 of 2020.
210.
Why it was dismissed?
Dismissed on the basis of the settlement.
Mr. Banerjee, you are appearing in this matter. On the basis of the settlement, you have the copy of that order.
It is one.
And MAT
It is at page
6766 of 2020,
31. Page 31 of 189, the main petition.
page 31 of the civil division application.
Civil division application.
So did you bring to the notice of the learned trial judge that this matter has been settled in mediation?
Settled in the mediation, Lordship, kindly.
Have you brought to the learned
We haven't had a chance till now because the matter was stayed by the previous order. And only on the last occasion we came to know, upon perusal of the other record, 397, we came to know that
So I'm
that
giving
is
you liberty, you approach the learned trial judge by saying that it has been settled.
we will approach the learned trial judge. Lordship kindly just makes an observation that the judicial parity, the parity between the parties on that
Yes, I will record. I am giving you liberty to file an application that I am keeping it pending. What is the next date fixed in the suit?
tomorrow itself.
Tomorrow. So this Finally, court today is taken on record. In spite of service, none appears.
I am for the petitioner. This was adjourned at the instance of the state, my lord. Your lordship, this matter.
Appeal at the instance of the state.
Adjourned at the instance of the state.
Oh,
my lord.
adjourned
I
at-
am the requiring body. Here
Where
was
is the state?
No, I beg to appear virtually. I'm sorry I could not appear physically today.
The instruction.
Yes, my lord. I needed the instructions, my lord. What my instructions is, my lord, apart from the fact that appeals are already pending, my lord, filed by the state as well as the requiring body, my lord, I had filed an application and, my lord, essentially, my lord, in the nature of section 47, my lord, in the execution proceeding, my lord, that has been in way back in 2023. That is still, my lord, pending. That has not been disposed of.
the crux of the matter. What happened in the main matter, my lord?
Yes.
The petitioners, the opposite party, my lord, they are, my lord, the lessee of the land. Now, this fact would escape the notice of the LA collector, who passed entire award in their favor. These are resumed land under 6.3. They are holding under 6.3. So their status is lessee. So they are entitled to only an apportionment. But the LA collector missed this, my lord, and entire value was given to them. Now, in the appeal, which is preferred by the state, they have filed one application for additional evidence where they have, you know, brought in those documents that it is a leasehold land. So they won't get anything more than, actually it should be less than that, because they will only get the apportioned amount.
Yes.
This is the merit of
That
the
I
appeal.
cannot decide it now.
Your lordship cannot decide that.
Yes.
In this case, my lord, the only issue is, my lord, I am, my lord, not the judgment debtor. The decree was passed, award was not passed against me, against state. Now, in the proceeding, suddenly, my lord, they said that since they are the requiring body, they have to pay. So
who said?
State also suggested, my lord, and
yes,
suggested.
I do not have any instruction whether we suggested or not. I take.
Only for that I gave you time. So how can the requiring body be held up? There is no award against the judgment debtor.
I'm not standing in that way, my lord.
Any
Yes,
of
yes.
the assets of yours are to be attached. It's your assets to be attached.
I'm not standing in the way and as that regard, my lord.
Standing in the way of attachment, Mr. Mukherjee, please attach the property of the state.
No, my lord, not mine, my lord, but whether, my lord, they can proceed, the court can proceed against the, my lord, state requiring body or not, my lord. The challenge, my lord, that is, I'm not standing in the way. My lord, my only difficulty is, my lord, the entire award was passed, my lord. My lord.
For attachment is pending. 47 is also pending. The court, that
yes,
will. I am challenging two orders, my lord, by which the managing director of SBSTC was not directed to appear personally, furnish the account details, or else appear personally. I challenge that order.
Yes, Mr. Mukherjee, how
I
that
cannot.
can be-
I'll satisfy Lordship. Lordship, kindly seize the entire order sheet. I've got the originals, these are the photocopies. Lordship kindly says, I filed the execution on 19th March 2021.
I will given this copy to Mr. Banerjee.
Lordship kindly comes to order dated 27 September 2021. Typed copy. Most of them are handwritten. This is the typed copy. 27 September 2021.
Yes.
In this, Lordship comes towards the middle, learned advocate for the decree holder presses for the prayer of attachment of the PL account of the LA collector for the legal dues.
Yes.
On the other hand, the learned GP sought time for 2 months. Be that as it may, decree or judgment debtor is directed to furnish an affidavit on the next date, specifically stating if there is any stay in the judgment. The time of
This is against the LA collector.
Yes, yes. I'm showing that. Lordship kindly comes to order number 9, 12th April. Today is fixed for hearing. Learned advocate for the decree holder, learned GP for present. Learned GP files one time petition along with the letter dated such and such, and a Xerox copy of one check and Xerox copy of the order dated 12th March 2022 and effective 5/29 of 2019. Now, Lordship sees the order.
Yes.
This is the order, 22nd March of this honorable court. This is in the condonation application of the honorable division bench. Lordship kindly comes towards the third para. Learned counsel appearing for the respondent submits that he has no objection if such cost is paid.
This is cost.
Next, amount is not deposited stipulated period, delay is not condoned.
So amount will be deposited by the state.
Yes. Now, Lordship.
So why are you hauling up the requiring body now? Please kindly come to that straight away.
Yes. Lordship now comes to their petition which they filed, the state filed in the revision, kindly text of the revisional application.
Yes.
At page, first of all, my lord, my learned requiring body is a party to the proceedings.
Yes.
Requiring body is a party to the.
Who is the judgment debtor, Mr. Mukherjee? Who is the judgment debtor?
Judgment debtor is the state.
So,
But the requiring body is also party to the execution.
maybe, but he's not the judgment debtor. The decree is against the state. Mr. Mukherjee, the requiring body has to pay to the state. So it's the state who has to call upon the requiring body or not.
Submitting before the.
Show me that why it is upon the requiring body
26.
of the revision application. Yes.
This is the state's affidavit.
Yes.
In my application for attaching their PL account.
Yes.
At page 27. The judgment debtor state begs to submit that the acquisition proceedings of the instance of the such and such who is the requiring body and for whose cause the said acquisition was made by the statutory authority, the LA collector. The financial liability obviously of the South Bengal State Transport Corporation who has acquired ownership of the land by virtue of such acquisition. It may be mentioned that the amount towards the compensation determined by the collector has been paid in view of the placement of fund by the requiring body, where it is the liability of the requiring body to provide funds towards the advancement of compensation. The requiring body has been made the party neither in the land acquisition proceeding nor in execution proceeding. This is wrong. They are parties. Now, Lordship kindly turns to 2, 3, 4. The entire statements are as if they are not made a party, but they are parties all along. I will show from the order annex. Lordship kindly comes to page.
So
30.
this is the statement made by the state.
Yes. Now page 30.
Yes.
Roman 4. 46A of the CPC provides for issuance of notice to the garnished liable to pay such debt, calling upon him either to pay the court the debt due from him to the judgment debtor. Accordingly, PL account of the collector may not be attached since the decretal due is not the debt due of the collector. Par contra, it is the liability of the requiring body of the South Bengal State Transport Corporation who has been noticed to call upon the debt due from him. Now, then the prayer is, Lordship kindly says, the PLA account should not be attached. Under these circumstances, what could be the stand taken by the learned executing court, if I may ask myself?
Yes, Mr. Banerjee, have you filed any exceptions to this or any, because this is against you? Here you have not stated, state has stated against you.
No scope was given us to ask Milord to file any exception to this first. Secondly, Milord, if Milord the judgment debtor says that it's not my liability, somebody else's liability, can Milord the executing court Milord go beyond the decree and accept that and Milord shift the liability from Milord? No, maybe, but you have to be bound by the decree. You cannot ask anything beyond the decree. It is not between the state and the requiring body who shall place the fund, because Milord, the fact is this, Milord, SBSTC does not have any fund of its own. It is dependent entirely on the fund of the state. But since the decree is specific, they have to not get the amount through execution of the decree. They cannot go beyond that.
Yes, how soon you will pay this amount? What is your instruction?
Background facts are
PL account will be attached.
Milord, in view of the Milord, my application, let Milord that be Milord considered by the court, Milord.
That will be decided. First, deposit this, secure this amount. Everything will be decided.
Kindly consider one thing, Milord. The appeal was taken up. There, Milord, the additional evidence has been filed. The fact is, Milord, that they are the lessee. This was suppressed, Milord, and on the basis of some agreement for sale, they have. Let's not argue parallelly. I'm addressing. In that application, specific documents have been produced to show that they are the lessee of the land, and they by posing as the owner, they have obtained the entire compensation. No, it is not.
Mr. Banerjee, is there any stay in the appeal?
In the appeal, the amount was not deposited. But the appeal was being heard. Appeal was in the hearing.
If there is no stay, the decree has to be executed.
And give us some time, Milord, we shall get the appeal heard, because the additional evidence application was filed, to which, Milord, they wanted to file an opposition, because this fact has come to the notice of the court.
How much time you want?
Milord, kindly adjourn it for at least 8 weeks, Milord. We shall mention the matter.
No stay here. No stay here.
No, indirect with the order. No, I'm not praying for anything indirect. I am praying that, Milord, the requiring body who is not a Milord, the judgment debtor, he cannot be compelled to appear before the court and furnish the account. So by this, they are the stand of the state. Stand of the state. Yes. Can the state shift the ball to my court and say that you pay unless there's specific decree, my lord, they can get the application for execution and the attachment application heard. That is pending. They can get that heard, my lord. If there's order of attachment, there would be attachment, or if the 47 is allowed, my lord, then they won't get it. But without that adjudication, my lord, they cannot get asked, my lord, forcefully to pay the amount. That is what they are trying. That is what the opposite party is trying, my lord, to get it through our
application for attachment is pending.
pending.
Application of attachment
It is pending before the trial court.
Logically, since these letters, they are writing. The acquiring body is writing to the requiring body for providing fund.
Yes, Mr. Banerjee, you have been requested to provide the funds.
Now,
Have you placed the funds?
We don't have not the money.
Mr. Banerjee, that is between you and the state.
That is my submission, my lord, that it is between the state and the requiring.
So you
body.
solve it.
They can only get it
Mr.
executed.
Banerjee, either you have to pay or the state has to pay. State is saying that you are not placing funds. So if the state
we don't have the fund, but this arrangement, my lord,
this is the state knowing about this fact has asked you to place funds. So sort it out amongst this with the state.
no, this is not to me. This is to collector. The deputy secretary is writing to the collector, not addressed by me or addressed to me.
Kindly turn. Next page. Next third page. Divisional manager, South Bengal State Transport.
Yes.
Then the fourth page. Again.
Yes, it is
Yes.
to you.
So they are asking for the fund. Firstly, we don't have the fund.
Mr. Banerjee, you have to sort it out from the state.
No, that is why I am praying, Lord, kindly allow us to get the appeal heard. Because this is ultimately at the end of the day, it is the public money. If they by forcefully by getting it executed, yes, because you are dragging somebody who is not a decree holder, judgment debtor, not a judgment debtor. I am not a judgment debtor. Therefore, and they being the lessee, they by misleading, they have obtained the award for the entire money. They cannot get it. They can get only the apportioned amount. This point has been taken before the appeal court.
My lord,
That is pending. Let that be heard, my lord.
the requiring body, they got the benefit of the land. The acquiring body.
Also preferred an appeal.
Yes.
We have preferred
And
cross
the
appeal.
willingness
When this matter
Not the entitlement, that is why.
That point is also said.
Yes, call the next matter.
Item 323.
List this matter in the monthly list of. Yes.
Deeply obliged.
Yes, next. Who is appearing?
I am for the petitioner. I am for the opposite party, my lord. Yes. That it's a fact that, my lord, earlier occasion also a revisional application was filed. Then my lord, I have also annexed. Order has been passed by your lordship. It has been rejected. And I have not suppressed anything, my
No, what you are challenging?
my lord. Challenging is that, but 208. My police protection has been given, my lord. Second appeal was there several length. My respectful submission is that two plots 666 and 667, my lord. I am now at present, my lord, on the basis of the scheduled plot which was going to be executed, my lord, 666. I already left the plot of land, and now, my lord, I am little mechanic shop, my lord, was there 667, and I have annexed also the. Kindly see, my lord, the annexed, my lord, at that time, my lord, it has not been produced, and two relevant documents was not produced before your lordship. Therefore, my lord, it was, I have not submitted properly at that time. My lord, kindly see 75, my lord. My respectful submission is that where I am continuing my business, my lord, 666, my lord, 666 to protect the sender. I am supporting the execution. It should be executed where the degree is there. I am not denying, I am not contesting, I am not that is anything is well. I have not contested all the second appeal also, my lord. My lord, kindly protect the petitioner, my lord, where the 666. If he is not 66, then he will be executed, my lord, evicted, my lord, immediately. I will support, I am supporting, my lord. 666, my lord. That is my respectful submission. He is residing at the side of the, which is the 666, my lord, not 667. The scheduled plot of land executing.
Where is the written statement?
Written statement most probably. Actually, written statement most probably not given, my lord.
Why?
Actually, I have.
See your stand in the written statement. Let me see your stand in the written statement.
No, if it is, my lord, survey, by way of survey commission. If it is,
Let me see what is your stand in the written statement. Let me go back to the suit now.
no,
Sir, all these things are over.
yes, it is true, my
Yes.
sir. Yes, last stage.
Yes.
Last stage, my lord.
Yes,
If
yes.
any my lord, remedy is there, my lord.
Yes.
If the six,
Sir, don't obstruct the decretal property. Do whatever you want.
yes, my lord, it should be executed.
Yes, yes.
I'm supporting, my lord. I am
Yes.
supporting the execution.
Yes.
I have already.
I will record your submission that you are supporting the execution in the
Yes, my lord. 667, my lord.
decretal property. What is the decretal
Yes,
property?
my lord. Decretal property.
I'm not mentioning any
Yes, my-
666,
667, my lord. I have annexed, my lord. I have annexed the this said property. By anyway, my lord, they are trying to get the said property also evict, my lord, and they will get the. It is my respectful submission, my lord. Only, my lord. It should be executed, my lord. I have already left the place, my lord. If any remedy is there, by your lordship. Minus is 75. Page 75, my lord. On that particular place, my lord, side of the place, my lord, anyhow, my lord, he is maintaining his daily livelihood on the by way of electric shop, my lord. 66. And executing plot is 667. That should be executed. My lord, I support, my lord. My lord, 666, my lord. If you know,
This application under
it
Article.
is my respectful submission.
This application under Article 227 Decretal property, don't obstruct.
They are saying this is also the digital property. This
That
is
I cannot decide from
this is
here.
the great problem. They are saying this is also the digital
Right.
property.
That I
Then
cannot
if I
decide
see-
from here.
If I say, my lord, it is not that
They will not go beyond the decretal
he is
property.
not going, my lord, they are going, they are, for which, my lord, they have come again and another. They are going, they are trying to get the, trying to evict, my lord, trying to evict.
Yes, yes.
They are saying also that this is the digital amount,
Yes.
digital property. My lord.
Yes. Call the next matter. Yes.
Anyhow, manage, my lord. Anyhow, they have managed the, they're trying to evict, my lord.
Yes.
I am appearing for the petitioner. CO 973 of 2024 was filed for the expeditious disposal of the municipal appeal, being Municipal Appeal 1 of 2018, which is pending before the learned civil judge, Junior Division, Bidhannagar, not 24 Pargana. But the erstwhile advocate who was looking after the matter could not appear on 18 November 2024, as her mother was diagnosed with cancer and was suffering from the pain of chemotherapy. So when the matter was called out, the matter was dismissed for default. A restoration application being CAN 1 of 2024 was filed within 30 days. That is on 17 December 2024. My humble submission before the Lordship is that kindly allow the restoration application.
How can I allow the restoration application, sir?
So it is filed within 30 days.
Maybe.
Restoration application.
That is not, if you file within 30 days, automatically it cannot be allowed. This application and
Your Lordship, restoration direct lordship to produce the LCR on the positive next date. It has been more than 2 years.
Yes, call the next matter.
I'm appearing, my lord. I'm appearing on behalf of the petitioner, my lord. On the last day, when this matter appeared for the first time, my lord, I could not reach, my lord. I'm extremely sorry, my lord. Can one is the application for restoration.
Yes, what is the main matter?
Main matter is CO 1565 of 2025. It appeared on 5th of May, my lord, for the first time. And by the time I reached, my lord, it was dismissed, my lord.
There's no caveat.
No. There's no caveat. My lord will kindly allow me to serve and come back.
What you will serve?
The main matter. If my lord,
What is this?
yes, my lord will kindly come to, it arises out of one motor accident claim case, my lord. My lord will kindly come to my list of dates once, my lord.
What is the impute or what has been done by
Yes,
this?
my lord will kindly come to page, immediately after page 26, my lord, at the last. One, I was directed to file one application, my lord. Has my lord found the impugned order?
Yes.
Yes, I was directed to file one application, my lord. Delay before the tribunal. There was a delay on my part, lordship, in filing that application. And I was also directed to pay costs. So that application.
No, where is the order of the High Court?
It's at page, my lord. It's at page 20. Page 20. Has my lord found it?
Yes.
That appeal was disposed of, my lord. The relevant portion is at page 21, the last paragraph.
Yes.
I was the delay in preferring such application would be tantamount to be condoned by the virtue of provision of section 14 of the Limitation Act if the appellant insurance company prefers the application within 6 weeks from the date of passing of this order.
Yes.
That 6 weeks, my lord, that there was a delay of around.
That cannot be condoned by the learned trial judge.
May I? I know. It cannot be. It cannot be. Two options I have. Either pray for extension in that appeal.
That is the only option.
I know. I only have for one thing before my lord. My lord will kindly restore this matter. I've already filed the application. I'm awaiting written instructions. Probably I'll be withdrawing this CO.
Nothing remains. If you did not withdraw, there is nothing remains. If I applied, I'm disposing.
My lord.
Recording that you have applied.
No, not now. My lord, kindly appreciates one. Give me 1 week time. I'll come back with the
Nothing will happen because this order the learned trial judge cannot extend. That is the only option. You do not have two options. This application can one
behalf of the petitioner. Time nebe.
हाँ कल कल कर लो बोल दो
Yes, yes. Why?
previously the hearing better than opposite party for 1 and 2.
Order 39, Rule 1 and 2 allowed without hearing us, without going through the written objection filed by us. Previously, ad interim was allowed, police help was allowed ex parte.
Yes, since an accommodation has been paid for.
Kindly please to fix a time, my lord, because this
Yes,
matter
it
is
will be fixed.
continuing since.
Yes, yes, call the next matter.
To be able to shield.
It may retain its position at least, my lord.
Yes, others are to be given a chance.
My lord, I am for the petitioner, they are for the opposite party, they have sought for time, my lord.
Yes.
My petition is getting, my lord, kindly, my lord, if my lord, kindly indulge.
You want to move it today?
One indulgence,
Yes.
just one indulgence, my lord.
Yes. Yes, move it.
Just one indulgence, my lord. That's
Yes, you move it today.
It-
Not tomorrow business.
very well, my
Today.
lord. I will move it today. And Mr. Chatterjee is also there.
Mr. Chatterjee is not there.
Not there.
Yes.
Very well. Well, this is a suit for declaration and
Yes, yes. Don't
for
forget.
declaration and permanent injunction. My lord, this suit was filed, my lord. My lord, this suit was filed sometimes in 13th of December 2021.
Yes.
My lord, the Mutwallis have filed the suit against we are for the defend number 1 and others are board officer in charge, chairman, municipality is there, my lord. They are there. No, no, বলছি। বলছি। দেখাচ্ছি।
Yes.
So, my lord, it is their suit. In their suit, they have filed an order 39 rule 1 and 2 application that was allowed ex parte. Ad interim was granted. After that, they have taken out an application for police help. That was also granted ex parte. After that, my lord, this main application came up for hearing. That was allowed without hearing the written, without hearing me and without taking into consideration.
What can be done if you do not participate in the hearing?
My lord,
You do not make any
my lord, it
submission.
was there. The written objection was there on record.
Maybe, but you
And
did
the
not
construction is
make any
complete.
submission.
And more so, my lord, I had many things to say on that because my title, the place from where I derive my title kindly looks into the judgment. I've annexed a judgment at page 27. Page 27 is the judgment from where I derive my title.
Yes. What is the order of injunction passed?
Finally disposed of.
No, no. What is the order of injunction?
Status quo.
Not to make any construction.
Yes.
Illegal construction.
Strong.
So you want to
Construction is
make
already-
illegal construction?
Construction is already complete. Municipality has given me an hearing.
Construction is complete.
Yes.
So I'm recording that. So I'm recording that you have completed construction. No further construction that does not affect
No,
you.
no, 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 no. Construction, my lord, looks into it. My lord, I have also
You have said that you have completed the construction.
completed, almost completed. You just
Not,
come up.
now you are saying almost.
No, 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 no. My lord, substantial part is completed.
Now
But
you are
kindly
saying almost substantial. What are the more
substantial
adjectives?
part is completed. My lord, kindly looks into the photograph. My lord, I have annexed.
Recording that you have completed. No further construction. This does not affect
No, no, no.
you.
Substantial construction has been made already. My lord.
Yes.
Kindly looks to the photograph.
Illegal construction.
No, no, no. Legal construction. Municipality granted me hearing. Hearing, my lord, granted. It is at
Municipality
page.
granted you hearing. Why? So there was an allegation of illegal.
No, 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 nothing. Page 50.
Then why did the municipality give you a
It
hearing?
comes to page 54 once.
50.
50, 50.
Yes.
entire thing was recorded.
No, 50 is what?
Minutes of hearing before the chairman, Annexure E.
লাস্ট প্যারাগ্রাফটা কর 50 তে লাস্ট প্যারাগ্রাফ পড়া পাল্টে যাচ্ছিস কেন
But kindly look to the last paragraph. In the above facts and circumstances, all the document, it has been revealed that the said plot of land is not enrolled under the Board of Waqf under EC number so and so Waqf estate according to the letter of Deputy Chief Executive Officer and SPIO Board of Waqf West Bengal mentioned above. Further, it has been also revealed that the building plan has been sanctioned by the Board of Councillors of the municipality according to the required and relevant document as per Rule 11 of the West Bengal Building Rules 2007. Therefore, the objection dated so and so filed by Nihal Ahmed Shaileji is rejected. Thus, the matter is disposed of. There was an RTI filed by me, my lord. The RTI is at page 49. When I have asked for the whether this property is enrolled with the Board of Waqf or not, the Board of Waqf answered it in negative. Page 49.
তোরা কোনো ডকুমেন্ট দেখাইনি উইথ রেসপেক্ট টু দি
আমি জাজমেন্টটা দেখাবো আগে জাজমেন্টটা কিন্তু তোমার টাইটেল
কম্প্রোমাইজ হ্যাঁ সেটা ডিটি হয়েছে এক্সপেন্ডিচার ওরা দেখাতে দিস প্রপার্টি ওয়াজ
So don't create third party interest in the property.
third party কেন the entire
Don't create, construct, don't create third party interest in the property.
but then they must have
Otherwise, Mr. Chatterjee, whether you have, that is to be decided. So if third party rights are created,
time of AC, let them show a document that this is a work of property. Nothing, nothing, nothing. Even before the honorable court, before the work of tribunal, my lord, I'll show your lordship.
Mr. Chatterjee, I will permit you to complete the construction, but you have to file an affidavit that you will not transfer the, not create any third party interest in the property. I will direct these proceedings to be disposed of.
Gives me 1 minute's time. Prime officer finding any
Of the petitioner are pending. Is pending.
Order 39, Rule 4.
For 39 and 4.
That I will say, that I will dispose, I will direct the main proceedings to be decided.
Give me 1 minute, I'll send them to take instruction.
If they do not create, they will not claim any equity with regard to this construction. If it is found, it will vest to the Waqf.
Lord, order 39, rule 4.
You are saying it's a Waqf property. It will vest to the Waqf, they will, that is why I am restraining them from creating any third party interest.
You carry on the construction.
Construction according to them is substantially completed. What were you doing? Yes, give me the photographs. What were you doing in the meantime? You have allowed these constructions to come up.
And the municipality has said that it is not a work of property.
The gully, this construction cannot come up in one day.
11 SCC নিয়ে আয়।
Substantial.
This construction cannot come in one day.
Lordship kindly sees.
Now Mr. Chatterjee will bring 2008 volume.
Yes, I understand. Substantial construction part
Cannot come within one day.
judgment, yes, substantial construction part. But there are other conditions in the judgment also. There are other conditions in the judgment also. Lordship knows that very well.
What conditions?
Yes, they will have to.
Yes, that is why if you have allowed these constructions to come up, it has to be completed, but third party rights cannot be created. Because we have allowed these constructions to come up. So we have approached at a belated stage.
I am saying, they are not entitled to.
Because this order of injunction was passed, an interim order of injunction was passed.
And how, may I ask
So
this question?
prior to this construction was made. Prior to this
So
construction was
whether it
made.
is prior to that or not, I am not.
Has
in a
to be.
position to say.
Is it your allegation that
This is not a dated. This is not a dated
All right.
photograph.
Is it your allegation that in violation of this order of injunction construction has been made? That's not your allegation. You have not taken out any application to that effect.
During pendency.
So are you disputing that this is the extent of construction? You can, I will allow you to take instructions on this.
Well, may I come back tomorrow? Because, my lord, kindly appreciate one thing. 39-4 application is pending. Their grounds in the,
Mr.
Well,
Galit,
their ground
will
is,
remain in order that and rule 4. I am not interfering with the order of
no,
injunction.
their ground is that tribunal is not functioning.
Milord,
But as on date, my lord, tribunal is functioning.
I am reminding my learned
Will we allow the forum to adjudicate on the issue, lordship?
Of what issue?
Whether, my lord, the injunction at all to be vacated or not?
No, I am
Yes,
challenging on that.
I am not vacating. I am rejecting their application order that and rule 4. You will be agreed by that. I am dismissing their application of order 30 and rule 4 from here. You cannot be agreed by that.
Lordship.
So, I am allowing them to construct.
But the consequence? To allow the construction.
Not to create any third party interest.
But to continue and complete the construction.
Yes, that is 2008 volume 11 Supreme Court cases page 1.
Yes, lordship.
Because if this is the extent of construction, when you approached for an order of injunction, construction cannot be stalled because this is the expenditure which they have undertaken, and you kept quiet, allowed them to raise constructions up to this extent.
My lord, kindly cease. Matwali is there. Matwali has been. Dekhao tumra. What are the communication you have been making with the board and the corporation?
Well, we have.
Mr. Trivedi, what were you doing? You have allowed this construction to come up.
I was doing a comprehensive list of dates. Comprehensive list of dates.
No, comprehensive list of dates. Was this construction made prior to your obtaining the order ad interim injunction?
My lord will kindly appreciate. The entire thing was triggered off because of one particular right to information reply given by the WAC. Before that, there are series of orders. The order was passed by the WAC for their eviction. After that, who are the erstwhile vendors of my learned friend's client, the order was passed in the month of May. They sold off the property, suppressing everything, just showing a decree which is neither here nor there. That decree was simpliciter by a civil court where Waqf court and neither the Mitwali was not even a party.
But it was declared to be a secular property.
No, it was not declared.
It was.
Threadbare, I'll go through that judgment.
Yes,
Which
yes.
shows I'm out.
How much time he will take?
My lord, let him. If my lord has crystallized the point, this that what I was doing. I have to show my negligence or my diligence.
How much time he will take?
My lord,
I'm asking you. That is why, accordingly, I will fix a time. That is why I'm asking.
My lord, the best time.
How much time?
My lord, at least 20 minutes.
Mr. Chatterjee?
I wouldn't take 15 to 20 maximum.
Mr. Galit?
0.
21st of July? 21st of July.
I'm sorry.
That's the best time.
21st of July. I have no issues, because I stay at Dharmakala. I'll take a walk. But my lord,
He will join
No.
virtually.
Mr. Trivedi will have to be in court on 21st of July.
So,
There is
but Mr. Chatterjee, you can join virtually. You can join virtually.
friends are offering to attend court in another matter. He was saying that let us come on 2nd of August. Today he is in that mood.
Mr. Gali will take 0 minutes.
Ashun.
তুমি তো adjudicating
It's at 4:15. Not at 2
4:15.
PM, Mr. Chatterjee, no motions can be.
Then-
1 hour this will take.
Then
Yes,
at
yes.
3:30.
My lord,
3:30.
because otherwise if there's a resolution, if there's a consensus amongst all of us.
Yes, yes. Mr. Chatterjee appears. Yes, next.
Mr. Chatterjee appears, ma'am.
Your Lordship, Lordship, actually, not very,
What happened?
actually, Your Lordship, we're praying for upgradation on a very serious issue. Actually, this matter was came up for hearing on 12th, and the matter was supposed to fix on 14th.
Sir, today it cannot be taken up.
No, no, sir, actually.
Come tomorrow.
My lord.
I am actually my lord.
Come tomorrow, 10:30.
Shall good one.